Hello, good evening. Hello, welcome everybody. Just getting my last few pieces set up here for tonight. Hello, welcome in. Good to see you all. Happy Monday. Oh my goodness. Okay, getting everything set up. Oh, well, thank you. I always appreciate getting comments and getting different ideas. Thank you very much for that. Am I partied out? Nope. It was a great, fun adventure. Didn't overdo it. So I had to make sure I didn't overdo it. It was a lot of fun. For sure. Big fan. Oh, thank you so much. I'm glad. I'm glad. I'm here to kind of help everybody learn a little bit and figure out how everything's working because it's a little bit crazy out there. So, happy Tuesday from New Zealand. Well, hello. Welcome, Lester. Good to see you. Did you have great food too? Yes, we did. Although I feel like any food that you don't have to cook yourself is good food. So it was a lot of fun. Oh, learning. I'm so glad. I'm glad. Hello. Welcome. Yes, it was a very fun weekend. I had a quinceañera celebration this weekend, so it was very interesting. Have you heard anything about the Murdaugh retrial? Okay, I've not, although I did hear. So he did go in and plead guilty just a few days ago to the financial crimes that he was charged with. So that's the latest update on that. But I do not have a new date yet for his retrial or new trial. That's not been completely fully argued out yet. But soon, probably, I'm assuming, now that he's pled guilty to his other charges. So Hawk recommended. Oh, well, good. Oh, yes. Hawk is, yes, he's very fun. I enjoy the Hawk. He's funny. He's a funny guy. Very great, interesting ideas. I love his takes on things. I love how he just sets it up and knocks it down. He's not playing. That's one of my favorite things. Well, good evening. Hello. Oh, absolutely. You're welcome. You're definitely welcome. As soon as I hear, I will let you know. I had even wondered if they were going to have the hearing posted up on YouTube. So I had been waiting for that as well. So I'll keep an eye on it. That's true, Preston. Indictments are finding of probable cause. So that's what they are. Trials are proof beyond a reasonable doubt. So that's the key. Here, hello, VC. Good to see you. Perhaps not. Now, where he goes and what he does, that's not up to me. I'm just explaining the law to people. So, hello, Suze. Welcome in. Yeah, it's been a busy couple of days. So, I'm glad to be back on again and saying hello to everybody. Toledo, Ohio. Well, hello. I don't think I've ever been to Toledo or through Toledo. I've heard of Toledo, though. Very nice. Hello. Hi. Welcome, everybody. Oh my gosh. Is it Monday? We have a short week this week. Well, some of us do. Others do not. But, you're from Ohio as well. Love that. Is he ever going to be held accountable? I think it really depends on what your definition of accountable is. But yes, I think so. I think there will be some accountability coming along. And I think it's already started. But this is just the beginning. It took years and years to get to this point, and will take years to untangle as well. So, right. There they went. Off they go. Moderators are here. Yay. Hello from Denver, Colorado. Oh, hello. So, yes, we're going to be going over the Colorado case. Fascinating. Hi from Iowa. Lovely. Hello. Really? Oh, for goodies. Oh, I love that. Goodies are always good. Denver as well. Love it. Yes, love that. That's fantastic. Yes, I think it's you've got to go and get yourself some happiness. Sometimes it's in the form of some goodies. Yes, the quinceanera. Yeah, the quinceanera was fun. It was very fun. Yes, we're just starting tea. I came on a little bit early tonight to make sure everybody got notifications okay and gave everyone time to come in. Am I a Democrat or a Republican? When I'm talking about the law, I'm of no party. I take the stance that Washington took, which was I choose no party. So when I'm teaching about the law, what do you think about the DC judges questioning the prosecutor and defense today? Oh my gosh, Taylorina. Oh my goodness. I did listen to the oral arguments in DC on the gag order. It was over an hour and woo, there were some crispy critters in there. Some very, very crispy critters. I think the judges were firing pretty quick on both sides. So I thought it was great. It was very interesting. I thought they had excellent points. They really dug out the weak links in both sides of the argument. So I thought they did a great job, a very great job. Yes, I agree. It was kind of nuts, wasn't it? Especially, we don't really hear those aggressive arguments that much, unless you're really looking for it, or you're part of it. But, I think I think it was pretty good. I think it was pretty good. I thought they did great bringing up all those issues. Yeah, I think there were, yes, so Taylor and Kelsey, I'm assuming you're talking about Miss Taylor, right? I heard that there was some unfortunate things going on at her concert recently. Oh my gosh, my heart goes out to them. Absolutely goes out to them. I feel terrible in Brazil. Yes, Miss Swift in Brazil, they were having some issues there, and I know she's been getting some backlash for that. So hopefully, oh, she lost a fan. Okay. Oh, that's so sad. That's so sad, especially if you have no control too. How frustrating is that when you're on stage and you can see everything, but you can't stop it? That's going to be very frustrating. And she's very protective of her fans too. So there have been times where she's interrupted a concert before. But yeah, it's sad. My heart goes out to her, goes out to everybody. So beautiful comeback. She stayed an extra night. Really? Oh, that's fantastic. Oh, yeah, the heat is bad. If you've ever been, oh my gosh, if you've ever been somewhere where it feels like you can't even breathe, it's so hot, it just can get really overwhelming for sure. Did not allow outside water in. Yeah, and, that's, yikes, that's a lot. It's a lot. So hopefully she'll be okay. She will, heal from it. I guess learn how to deal with very incredibly difficult situations. Okay. Oh, really? Oh, well, I do wish her the best. She's an amazing artist, absolutely amazing. I remember when she first came out, I'm not going to say how old I am, but I'm old. And I remember when she first came out thinking like, wow, that's interesting. Okay. Handled it with grace. Oh, we love to hear that. Will the DC judges allow the gag order? I don't know. That's another thing about the arguments today is that when I finished, I had no way. I could not figure out which way the judges were going to go. My thought was they were going to try to kind of make it so that change the wording around a little bit, but I don't know. I really don't know. I can't do that. I never lived in the South. Again, I had a hard time with the summer in New England. Oh, absolutely. Yeah, heat is not my friend. Heat and my hair are happy friends, and they're very good partners, but I am not a fan of the heat, for sure. I don't like the cold either. I'm more of the California temperature. The best weather ever was, every time I've been to California has always been the best weather forever. Yes, it is. Now, David, we're going to crack this open. We're going to crack it open like a walnut. I'm using a term most people should know now rather than a tauntaun. But this case is actually really fascinating. It's really interesting how she kind of pulled this case apart. It is perfect weather. I agree. Well, I enjoyed Florida, fair enough, but I feel like it's just a bit too tropical, and there were unidentified creatures there that made me uncomfortable. So I prefer more of the, concrete of the LA was my preference. But did enjoy my time. I've enjoyed my time when I've been in Florida too. But yeah, there are just some interesting creatures out there. Yes, we're gonna crack it open like a nut. So welcome everybody. Welcome on in. Fun but sweaty. Oh, accurate. I think that's accurate. Yes, I've enjoyed it. I would say I don't think there's a single state that I haven't. Well, I'll be honest with you. I think the only state I really ever struggled in as far as the weather was Arizona. I think Arizona was so hard because it was so dry. I felt like my eyeballs had actually dried, like I couldn't look to the left or the right. So that was the only place I had problems with. Yankees, very funny. No, there's all kinds of little creatures running around there that we don't have in my neck of the woods. For sure. Yeah, I mean, Arizona I thought was very beautiful, but oh my gosh, it was dry. No, I've not been to Vegas yet. That's on my list. On my list. For sure. It's getting drier. Yes. Well, I felt like I could just not hydrate enough. I swear I drank more liquid there than anywhere else in the world, but could not get hydrated. Horrible in the summer. Oh, I bet. I have dear friends that moved there because we get pretty significant winters where I'm at. And she moved to Arizona for years and years, and I wanted to go visit, but I was like, oh, I don't know. I can't do it. Oh, breathing sand. Yes. It's just, it feels like it actually takes liquid from you. Like your own, like, water that's in your blood, your veins. It just takes it away. So can you get to the point? Sometime I'll get to the point. Oh no, he's gone. Oh no. Make sure to use your sarcasm emoji, everybody. Oh my gosh. Great to visit in February. Oh, I bet. Well, it's beautiful. I mean, it's absolutely beautiful. Some of the most beautiful skylines I've ever seen were there. Yes, yes. You got to be careful about that. Yeah, it was just too dry. It was too dry. Oh, we're talking about Arizona right now as everyone's kind of coming in. I'm keeping an eye on the clock here to give everyone a few minutes to come on in. So just drink lots of water. I did. I was drinking water. I didn't have any soda. I didn't have anything that was dehydrating. Well, except for alcohol. There was that. I won't deny that. I would, that's all right. But Oklahoma is cold and rainy. Oh, yes. Oh, Oklahoma is fantastic too. I had some fun in Oklahoma. From Philly, yes. Love Philadelphia. One of my favorite places in the world. Just about anywhere south or west in February. Fair enough. Death Valley was crazy. Yes. Now, Vegas is the same as Arizona. I have not made it to Vegas, so I do want to get there someday, though. Someday. Bailey's and cream yesterday. Took a 3-hour nap. Worth it. Chris, that's so funny. That was always my finish whenever they had last call at a pub. I would always get Bailey's. That was my last drink of the night. It was a little dessert. Oh, love it. Absolutely. But of course I was legal. So it was all legal. Everything was fine. Following the rules carefully, everybody. Oh my goodness. Yes. So, well, welcome in everybody. Welcome. I've got a treat for you tonight. This Colorado case just north of San Francisco. Oh, come visit. Yes. New Orleans. Oh, New Orleans is pretty amazing too. Oh, thank you. I've got my Thanksgiving pumpkin pie nails on tonight. So very excited about that. So let me go ahead and start diving on in here. Just to remind everybody, make sure that you do. Hello, Alan. Good to see you. Make sure that you do make it known that you are being sarcastic, just so that our poor moderators know what you're talking about. Sarcasm can sometimes come across as troll work. So, we're not huge troll work people here because we try to keep the learning going. So just so you know, we typically will go ahead and mute first. And yes, the moderators work so very, very hard. I'm so very, very thankful. So just to kind of see that again. So, yes, sarcasm. Yep, put your, and I'm sure Deborah will be in here soon to remind everybody too, but thank you, Suze. Appreciate that. Filing an appeal on this case. Yes, I don't doubt it. I don't doubt it. Yes, for the moderators. Yep. We just, it's amazing the kind of comments people send in here that they actually mean. So we have to be careful. Even some of I may need to start closing up my, we have zero tolerance. Yes, see, and we just learn here. We're here to teach and learn, and there's lots of fun places to go and argue angrily, but use the wink, use something. Hello, Deborah. Oh, you're here. Good. Oh, Deborah, I was worried. I wasn't sure. That's our quotation marks, asterisk, something. Yes, exactly. Is this a federal case? This is not. This is a Colorado case. So I will be taking everybody through the Colorado case tonight. Now, I've got a little bit different strategy because this case is fascinating, actually. This judge wrote an amazing opinion. I'm not going to say if I agree or disagree, but either way, it's very good. It's very well written. So what I will take you through is we'll kind of go into the facts a little bit. There's multiple pieces to this. So she really took her time. The other thing that is so fascinating about this order is she was absolutely meticulous in citing every single exhibit, every single transcript, everything that was said. So for each piece that she wrote about, she is citing it directly from evidence. And so I've never seen anything quite this thorough before. This judge really set a new standard. Now, she goes through the facts here, and I'll break these down for you. I won't read through verbatim, but we'll go through a lot of them. And then what I've done is I've pulled out really the highlights, the big pieces that are the most important for her holdings. So she starts out with the facts, and then she starts going into her legal analysis, and that comes quite a bit later. But she goes into the First Amendment. She goes into the Brandenburg test. So she does an amazing job. So I will take you through that tonight. And it can be a little bit difficult to understand here, so we'll definitely take our time to walk through it as we go. So I'm just double checking to make sure that I'm lined up. Am I lined up okay in here, everybody? B. Flintstone, yes, of course. Glad to see you. Always glad to see you. So hopefully I'm in. You may have to remind me if I get out of frame, everybody. So let's go ahead and get started then. So this was filed on November 17th. And sticky note, thanks, Deborah. Let me just get the sticky note before I forget. Okay. Colorado, 14th Amendment. 14th Amendment. Final order. Okay. So, get that on there. Oh my gosh. Hello. Okay, I'm good. Okay, good. Thanks, Nancy. Yes, excellent. Love to hear it. All right, everybody. So, again, this is really a very, very interesting case. Okay, now, Deborah, I'm going to wait until I turn to page 2, okay? But if I forget, feel free to just come after me. That's fine. So we've got a Colorado case here. We've got Norma Anderson and several other petitioners against the respondent, who is the Colorado Secretary of State. Now, these are the parties, and what they have in Colorado are interveners. And so there were 2 other interveners here. So we had the Republican State Central Committee out of Colorado, and then Donald Trump, who could come in as interveners. Their status is lower than that of one of the 2 parties, but they were included. They were allowed to make arguments. They were allowed to ask questions and so on. So they were added in, but not technically parties to the case. So let's go through this. So now I'm really got to make sure I don't forget my sticky note, everybody, when I flip the page here. So don't let me forget. Hold on, I've got to put there we go. Get this set up properly here. All right. So I'll skip through probably quite a bit until we get to the legal arguments. Now, we've started here, and she's setting out. It came in front of the court from October 30th to November 3rd. And then she's setting out here who the petitioners are and the secretary. Now, she does go into the interveners. So she's got intervener Trump, who is represented by counsel. And then we've got the other intervener, the Colorado Republican State Central Committee. So they came in. The court, having considered the evidence, the extensive briefings, and proposed findings in fact and conclusions of law and applicable legal authority, makes the following findings of fact and conclusions of law and issues in the following order. So the facts that we will go into here are really amazing. I would say at this point, there's been this huge question. Was there an insurrection? Was there an engagement? This judge answers those questions. I think it's fantastic because now we've got a foundation. So she laid the groundwork, everybody. She laid it down. So here's the procedural background. Again, I'll just kind of skim through this on what was filed and so on. We've got the petition filed. We had a removal notice here, motion to intervene from the Central Committee along with Mr. Trump here. And that's 2, and then 3. And then there was a motion to dismiss that was filed by Trump. That was denied. We also had another motion to dismiss, and that was also denied. So I'm just taking you through the procedural history quick. And then we had one more. So we had multiple motions to dismiss. All of them were denied. And then we had the Central Committee for the Republican Party. They filed a motion for judgment on the pleading. So they wanted, it's basically like a summary judgment, like what happened in New York. They filed that, but the judge said, nope, we're not going to have that. So the court did grant Trump's motion to intervene on October 5th, right before it started being argued. And then on October 11th, there was another motion here that had been denied. So they didn't want to deal with the SLAPP issues that were going on. And I'll save that for another night because this is over 100 pages and it's really not relevant to the arguments here. So we've got an omnibus ruling on the pending dispositive motions. So the relevant motions here, again, denying the motions to dismiss and then setting it for the case, setting the case for trial, which is what we heard. Again, we've just got more motions that had been filed. She takes us through all of that. I'm just skimming through this procedural history here. We've got briefs. We've got a motion in limine that was filed. We've got another one regarding objections. And a 5-day trial was set then for October 30th. The petitioners, the secretary, and the interveners provided the court with proposed findings of facts and conclusions of law. The court has incorporated some of their findings of fact and conclusions of law in whole or in part, but only after careful consideration and adoption. So, and like I had said before, she just cited her evidence all over the place. This is so incredibly well written and cited. So here's her first piece where she's starting to kind of walk us through the facts. So the first few sections, we'll go through the facts and then we'll go into the legal arguments. So the January 6th report, first of all, she did rely on, she made a final decision regarding the admissibility of the January 6th report. And she said, yes, it could be allowed under Colorado law and under case law, it's allowed. So she's going through the analysis on why that January 6th report can come in because it's a congressional report. So that was fine. Here, so the interveners, again, whenever you see interveners, this is Trump and the Central Committee, they had to argue about particular levels of admissibility with the January 6th report. So again, I'm going to kind of jump through this because I really want to get to really the meat of this case. So she's going into, again, why she believed the report was okay. The plaintiffs responded to the report as well. So here, while the court agrees with interveners that the January 6th report would have further reliability had there been greater Republican participation, the events pointed to by the petitioner demonstrate the Republicans had a meaningful opportunity to participate, but simply chose not to. What was the name of the case in the pink in the last page? Oh, sure. I was too quick. So anytime you see pink, I'm highlighting cases here. So these are the cases she's citing regarding the admissibility of the January 6th report. So we've got Beech Aircraft here, Berry versus International Full-Time Salaried Officers here, the Berry Case Beach. Those are her two primary cases that she's citing. Then we've got Barry Mariani here is on page 11. The Hobson-Wilson case is also on page 11. Then we've got a McFarlane here, which is a Westlaw citation, and then she's citing McFarlane again. So those were the big cases she's relying on. You bet, anytime. All right, so so the court is cognizant that the then Speaker Pelosi rejected 2 of the 5 recommended Republicans for the committee, and the minority leader put forth, and she admitted this decision was unprecedented. The fact that the congressional Republicans chose not to seat the 3 Republican members that Speaker Pelosi was agreeable to, or to nominate a new slate of potential members, and instead chose to boycott the committee, is not a valid reason to reject the January 6th report in total. So again, she's just setting up why she allowed for that particular piece of evidence. This judge is nothing if not incredibly thorough. So she just is continuing to go on about allowing that report in. Now, I will get to that report later, but this is just her legal analysis on why she said that it was okay to come in. So let's get into more of the crux of the case here. All right, so she does do an overview of the hearing testimony. That's really where she starts. We've got section 3 going through the witnesses, and I'll just do a summary here of the witnesses, very brief, and then she will go into the findings of fact. So first of all, the petitioners, again, those are the voters in Colorado. They pulled in multiple witnesses. Their first witness, Officer Daniel Hodges, and he was an officer in D.C., and he kind of went through what happened. I think his testimony was some that I did do a live on here. So what I'm really looking for throughout her entire order is her findings. So anytime she's putting something in like the court found or the court holds, that's really what I'm looking for. So we have, are those cat faces on? No, they're pumpkins. They're upside down pumpkins. Not very good. They look like pumpkins to me. Oh my gosh. Okay, so the court found Officer Hodges' testimony to be credible. The court gave weight to Officer Hodges' testimony in finding that there was an insurrection and that the mob was there on Trump's behalf. So his testimony was important to her, so she just kind of announced that. Next, for the plaintiffs, we've got Congressman Eric Swalwell, who testified, and he was going into how he was terrified about what had happened that day, recounting his role in the impeachment of Mr. Trump. And so she goes on to say she holds that he is, regarding his experience on the Capitol, he was also credible. The court gave weight to his testimony in finding that there was an insurrection. So again, with this judge, it's amazing because she tells us, first of all, was he credible? Yes. And what did you rely on his testimony for? She relied on it in determining that there was an insurrection. So next, we've got for the petitioners again, this is the sign for the petitioners, just so you know. Officer Winston Pingian, police officer, United States Capitol Police that day. He was in the civil disturbance unit with 25 other officers, pushed and assaulted, pepper sprayed, and so on, hand-to-hand combat for up to 3 hours. So the court finds his testimony credible, gave weight in finding there was an insurrection, and that the mob was there on Trump's behalf. So this piece here, that the mob was there because he asked them to be there, will come back in later in her analysis. The sign is off. Oh no. All right, the sign up here. Hold on, there we go. I've got a couple of different angles that I'm looking at. So, all right, I'll keep it more towards the middle of the page. Here we go. Professor Peter Smith, he testified for the plaintiffs as well, the petitioners. Professor of sociology at the Chapman University, qualified as an expert in political extremism, including how extremists communicate, how the events leading up to and including January 6th relate to long-standing patterns of behavior and communication by political extremists. Again, this comes in later in her analysis when she's talking about insurrection. let's see, studying political extremism forever. So he went through and explained the Oath Keepers, the Proud Boys, the 3%ers, testified about the 217 right-wing extremists, and the 14 of those interviews were the Oath Keepers, Proud Boys, and 3%ers. Now, she came further to say that the court gave weight to his testimony in finding that Trump intended and incited the violence. So that's why his testimony was key, was because it went to Trump's intent. Yes, make sure you use your sarcasm emoji if you're joking, everybody, because some people come on and they're not joking, and that can be scary. Tea break. Just 1 minute. All right, here we go. So, yes, this is an amazing, it's so well written, everybody. All right, here we go. So finds his testimony credible, helped the court to understand that while Trump's words, both before and after January 6th, might seem innocuous to the average listener, they would be interpreted differently by political extremists. I thought this was an amazing finding. You know, too, a lot of these findings as we go through this are something that can be used in the DC case, right? So we had an intentional interference with an official government function and an attempt and an interference with voting rights. All of those things are on the DC indictment for Mr. Trump. So to have a finding like this can absolutely be used in a very similar way. They can find a very similar, if not the same expert, to come in and testify that maybe a normal, regular person would have said, well, yeah, he was kind of, whipping up the crowd. But when someone is an extremist, it has a different view. It has a different way of looking at it. And by that testimony, it was very convincing for the judge. So that First Amendment argument really flies out the door when we have a situation where you're dealing with extremists because they interpret the language differently. So I thought that was a very interesting finding. Setting them up for the long run. Yeah, I think all of this is for the long run. It takes a long, slow time, but we will see how things go. All right, Professor Banks testified again for the petitioners, a law professor at Syracuse University teaching constitutional law, national security law, counterterrorism law, and domestic role of the military. She goes into his background a little bit more here. Advising the Department of Defense and civilian agencies here. So she qualified him as an expert on the president's power to stop domestic attacks on the government and the authorities of the then President Trump, the authority he had to call on the stop of the attack. That's another big piece of this opinion, is she came in and she said he had the power and authority to stop it. And when he requested that they stop, they did. And so this expert came in and went through what he had, what Trump had in place in order to be able to stop the violence that was going on. So she will use this later in her findings. So she found his testimony credible and helpful to understand the authority. Could judges use this finding to do a summary judgment on whether there was an insurrection? Great question, Georgie. I don't think it could be used as a summary judgment, but it could absolutely be used as the foundation to build off of. This judge set that foundation to build on. Absolutely, she did. And she did an amazing job, in my opinion, with clarifying these things. Her rationale is amazing. Her evidence is clearly stated. So I thought she did a fantastic job. I wouldn't say it's enough for a summary judgment, but I would say it's definitely a great place to begin. I think she did a good job setting it out for everyone. She's kind of setting up the shot for everyone. All right, so he was credible. He was helpful. He could have called the National Guard in and the National Guard in other states and chose not to. Gave weight to his testimony in finding that Trump had the authority to call reinforcement and chose not to. Thereby recklessly endangering the lives of law enforcement, Congress, and the attackers. So that was another one of her findings here. Again, we've got Professor Gerard Magliacca, who testified again for the petitioners. a law professor at the Indiana University here, a constitutional law professor. She qualified him as an expert on the history of Section 3 of the 14th Amendment. She found his testimony clarified the history of Section 3, gave weight to his testimony, finding that Trump engaged in the insurrection. The court also gave weight to his testimony here. I thought he meant the writer. Oh, to testimony, but ultimately rejected it regarding whether Section 3 of the 14th Amendment applies to former President Trump. So she disagreed with that particular reason, and that's because she relied on other experts. So it's high praise. Yes, I mean, I'm very impressed. I don't agree with everything that she wrote, but I think she did an excellent job overall. All right, so she agreed with this person regarding the history, but did not agree with the fact that he would be included, and she'll get into that later. Thought Pelosi had the power to call the National Guard, and she didn't. Great point, Roger. There's a whole section coming up where she will explain exactly who he could have called in and where his authority came from. So I will go through that, but great question. All right, Hillary Rudy, on behalf of the petitioner, she's Colorado Deputy Elections Director and knowledgeable about how the Secretary of State's office has traditionally handled qualification issues. So she went into testifying about, well, what if they are under 35? What if they are not born, within the period of time that you're supposed to be born in? Those kinds of things. Those very specific qualification questions is what this witness was testifying about, because they have had some cases in the past where someone wasn't qualified because they weren't the correct age, or they didn't have the proper qualifications. So that's where her testimony came in. She said she was extremely credible, which is, you always love to hear that, gave weight to her testimony regarding the historical practices of the Secretary of State's office, including when it would traditionally prevent ballot access and when it would not. So she gave actual examples of when she kept people off the ballot, when they kept people off the ballot, and then when they didn't. So it's very helpful. Again, she's setting all of this up, but the analysis the judge will bring in here in just a little bit. All right, next we've got Timothy Heaphy, who testified for the petitioners. He was a former chief investigative counsel for the January 6th Select Committee. He was an assistant U.S. attorney and moved to private practice. Now in here, he's testifying to the investigation for the Unite the Right rally. He also worked for the January 6th committee from June until December the following year. She found he was qualified and a seasoned investigator, found his testimony regarding the inner workings of the Select Committee to be credible. This would be an excellent example of legal writing 101. Oh my gosh, it's so good. It's so good, everybody. This is not a Harvard Law Review article. And in my opinion, my humble opinion, that's what makes it so good. It's so user-friendly. It's very user-friendly. All right, she gave weight to his testimony, deciding to admit specific findings of the January 6th report. So she found certain pieces to be very credible based off of his testimony and then allowed that evidence in. Hot Cocoa Soon, yes, I think she did write it for the public VC. I think she did, and I love that. All right, now we're going to get into the interveners' witnesses. So here, this just means intervener Trump, as opposed to the Republican Party that was also an intervener here. Take tea break. All right, so we've got Kash Patel, or Patel, I don't know. Mr. Patel was the former chief of staff. What's the name of the person who wrote this? So this is written by Judge Wallace. She's a district court judge there in Colorado. Patel. I would not have guessed Patel. That would not have been on my list. But thank you for that. Patel. Oh no. Like Mattel. All right. I kind of like Patel. I think Patel's fun. But say it fast. Okay. We'll call him Cash. All right. So he testified Trump had authorized 10,000 to 20,000 National Guards forces. He talked about his experiences with the select committee. He was not a credible witness. What? So Mr. Cash was not credible. Patel. Oh, double T. All right. Very good. Potato. Welcome, Mr. Potato. Not a nice dude. Well, he was not credible. His testimony on authorizing is not only illogical, but completely devoid of any evidence in the record. Further, his testimony regarding the committee refusing to release his deposition and refusing his request to speak at a public hearing was refuted by a far more credible witness. So that's pretty harsh, everybody. Did not give any weight to his testimony other than as evidence that the January 6th Select Committee interviewed many of Trump's supporters as part of its extensive investigation. So there we go. Moving on. Next, we've got Katrina Pearson, who testified on behalf of Trump, a senior advisor to Trump's presidential campaigns. She tried to intervene regarding internal disputes that had arisen regarding the January 6th rally. According to her testimony, there was a meeting. He agreed to her position there. Should not include inflammatory speakers like Alex Jones and Ali Alexander. She also testified that Trump told someone in the room of the same meeting that he wanted 10,000 National Guards. The court has no reason to disbelieve this testimony, but mentioning 10,000 National Guardsmen is not the same as authorizing them. True enough. So the court gave weight to her testimony, finding Trump chose the speakers on January 6th, and he knew radical political extremists were going to be in Washington, D.C. on January 6th and likely attending his speech, and that the January 6th committee extensively interviewed witnesses who were Trump supporters. So that's what she took into consideration. Next, we've got Amy Kremer. Who's also is a Trump witness, the founder of Women for America's First. She hosted the rally at the Ellipse. Her testimony was like Ms. Pearson's in that she worked with Ms. Pearson and to keep the people she described as wackos from entering the Ellipse. The reason she didn't want wackos to speak on the Ellipse is because she was worried they might incite violence. So she acknowledged she remained by the event stage throughout the rally and didn't interact with anyone outside of the security perimeter, was unaware that in response to Trump's speech, some people in the crowd yelled, storm the Capitol, take the Capitol, and take the Capitol right now. So those are very specific. She personally did not walk with the crowd to the Capitol and did not go to the Capitol, but instead returned to her hotel immediately after Trump's speech. So her testimony was credible, but found her testimony to be largely irrelevant. So she believed her, but felt she was irrelevant. Next, we've got Tom Van Flein, whatever. Again, for Mr. Trump, Chief Staff of Congressman Paul Gosar testified he and the congressman and his wife attended here. The court found his testimony to be credible, but largely irrelevant. So he was also credible, but not important. So next we've got Tom Bjorklund, and he testified on behalf of Trump, Colorado Republican Party treasurer. So I think we watched this one too. He was not close to the stage. The court found the testimony that he did not see any violence to be not credible. So she felt his testimony saying, I didn't see any violence, she found that to be not credible, given that he saw people breaching the Capitol through the windows that they smashed. So that's a specific instance where she's like, how could that not be violence when you saw them smash through the window? Further, his testimony that Antifa was involved in the attack lacked credibility, was evidence of his inability to discern conspiracy theory from reality. What? All right, that's another huge thing right here, okay, everybody? So she's saying he doesn't know the difference between a conspiracy theory and reality. That's pretty major. Yes, okay. Yeah, that's pretty major. So I know I'm not saying the names correctly. I know. The court only gave weight to his testimony that not all of the protesters were violent and that he understood Trump to be directing the crowd to the Capitol and that he followed that direction. So I thought that was interesting again. Now, she did put a footnote in on his testimony. The court notes that it's uncontested that not all attendees at the rally, the speech, heard it as a call to violence. That is consistent with Professor Simi's testimony that the language of political extremists is coded so that there's a plausible deniability. I thought that was very important. So she found, all right, what she was saying was some people may not have seen his language as inflammatory or insightful, but that's only because the extremists, the political extremists, can hear the code. Isn't that an amazing finding? I thought that was an amazing finding by this judge. So if you can hear the code, you will go and you will listen to it, or the quote dog whistle. Yeah, I think it's very good as well. All right, now we've got Congressman Ken Buck on behalf of Trump, testified about his experience. He testified he was not particularly scared during the attack, admitted that it was because he did not have a cell phone, didn't realize the extent of the attack, found him to be credible, gave weight to Buck's testimony that the congressional reports are inherently political, so she agreed with that. And the minority leader actively prevented the committee from being bipartisan, including when he rejected Congressman Buck's request to be on the committee. So that's helpful. Professor Robert Delahunty, oh my goodness, testified on behalf of Trump again, a constitutional law professor. Okay, now I think we watched this one together, everybody. This one was a bit rough. Everybody has it's true, Sarah. You are right. That is weird. All right, so he was offered to rebut opinions of the other experts, and while he had nowhere near the experience of the other experts, he offered opinions that were helpful to the court. Assessing the historical context in which Section 3 of the 14th Amendment was ratified. Now, she didn't, I thought that was a very diplomatic way of saying that. Travis's buddy, oh, we love that. Travis. Oh my gosh. The interveners seem to have largely abandoned Professor DeHunty's testimony and cited only once in their 177 pages of proposed findings of fact and conclusions of law. The citation is for the proposition that the omission of the word incite from Section 3 means that incitement was not meant to be a form of engagement. So they used one word out of all of that. Buck is singing a different tune now. Really? Interesting. All right, so there we go. There's an overview of the witnesses, everybody. So let's get into the findings of fact because she really sets these out. I have to make sure my filing cabinet doesn't tip over that I'm sitting on. So tea break. Whew, okay. Yes, I thought she did a pretty good job. Bucket said he's not seeking re-election. Well, yeah, I would, that's what normal, it seems to me, now I shouldn't say that, but it seems like most people traditionally do not seek re-election after something of this magnitude, but at least sitting on a pillow. I am, Kim. I have a pillow on top of the filing cabinet. Oh my goodness, I've said too much. All right, here we go. Let's get into the findings of fact here. So she's going to start off with a footnote. So I think that's really important. She has some real gems in her footnotes. So let me dive into this. The court is denying petitioners the relief they request on legal grounds. All right. Because of the party's extraordinary efforts in this matter, the court makes findings of facts and conclusions of law on all remaining issues before it. I thought that was amazing. Can other lawyers use the findings that these witnesses are not credible to get them off cases? Absolutely. The court does so because it's cognizant that to the extent the Colorado Supreme Court decides to review this matter, it may disagree with any number of the legal conclusions contained in this order and the orders that precede it. The court has endeavored to give the Colorado Supreme Court all the information it needs to resolve this matter fully and finally without the delay of returning it to this court. Isn't that amazing? I thought that was amazing. Well, welcome in, Tiffany. Hey, it's better late than never, for sure. So I thought that was pretty amazing that she set that out. So she said, listen, I'm not going to rule for you, but I am going to give you some findings of facts and conclusions so that if I'm wrong, they don't have to send it back to me. They can take it to the next step. So I thought that was pretty amazing. All right, so we've got findings of facts. Subpart A. She filed an appeal on her own judgment. Well, she knew it was going to be appealed, so she set this up as an appeal. She meant this to be a foundation to start from. Did you ask Santa for a chair for Christmas? I need to. I should. Oh, my goodness. Yes, we have some very smart people. There are some very smart people in the field, which it's refreshing. All right, here we go. The parties. So she sets out who the parties are here again. We have the interveners here. So I thought this is important to kind of note here. The intervener that is the Central Committee for the Colorado Republican Party is an unincorporated nonprofit association, political party committee in the state of Colorado. So she's just setting out the parties. Next, we get into Trump's history with political extremists. So this is where we really start getting into the deets. Now, again, anytime you see a yellow highlight, she is quoting directly. She's pulling this from the transcript from the trial. Okay, so none of these are conclusions. They are made specifically based upon, or not just presumptions. They're conclusions made off of law that's been set out. Here we go. As noted above, petitioners called an expert in political extremism, Professor Simi, and a 27-year career focused on political violence and extremism. He's written 2 books, provided training to political extremism and violence for the FBI, Department of Homeland Security, and federal prisons. Simi reviewed Trump's relationship with his supporters over the years, identified a pattern of calls for violence that his supporters responded to, and explained how long that experience allowed Trump to know how his supporters responded to his calls for violence, using a shared language that allowed him to maintain plausible deniability with the wider public. This is so fascinating to me. I think this is just very interesting. Trump himself agrees that his supporters listened to him like no one else. Again, and we're citing an exhibit. Kremer also testified that Trump supporters were very reactive to his words. Simi testified about the following examples of patterns of call and response that Trump developed and used to incite violence by his supporters. So October 23rd, 2015, Trump said to his supporters in response to protesters disrupting the rally, "See, the first group, I was nice. The second group, I was pretty nice. The third group, I'll be a little more violent. And the fourth group, I'll say, get the hell out of here." And then again, she's citing her source. I know, I didn't know about the code speech either. The next month, Trump used this very language, telling his supporters to, quote, "get a protester the hell out of here," end quote. And the protester was then assaulted. When asked about the attack the next day, Trump said maybe the protester should have been roughed up. So they're going into examples of this coding language that he's using. At the February 2016 rally, Trump told his supporters to knock the crap out of any protester who threw tomatoes and promised to pay the legal fees of anyone carrying on the assault. At another February rally in 2016, he told his supporters that in the old days, the protester would be carried out on a stretcher and that he would like to punch him in the face. When asked about his supporters' violent acts in March, Trump said the violence was very, very appropriate and that we need a little bit more of it. At an August rally, he noted the Second Amendment people might be able to prevent Hillary Clinton, if elected president, and judges appointed by her from interpreting the Constitution in unfavorable ways. August 2017, when asked about white supremacists Unite the Right rally in Virginia, where a counter-protester was murdered, Trump stated that there was blame on both sides, some very fine people on both sides. Far-right extremists, including David Duke, Richard Spencer, Andrew Anglin, thanked Trump for his comments and took them as an endorsement. Notwithstanding Trump's condemnation of these people and white supremacists in the same speech, Simi testified that the latter statement would be understood as plausible deniability. At an October rally, Trump referred to a candidate who body slammed a reporter as, quote, my kind of guy. At a May 2019 rally, when one of his supporters suggested shooting migrants, Trump stated, quote, that's only in the panhandle you can get away with that statement, end quote. The crowd cheered. In a May 2020 tweet referring to an armed occupation of the Michigan State Capitol by anti-government extremists, he tweeted that attackers were, quote, very good people, end quote, and that the Michigan governor should respond by appeasing them. On May 29th, 2020, Trump threatened to deploy the military to Minneapolis to shoot looters amongst protests over the police killing of George Floyd, tweeting, quote, when the looting starts, the shooting starts, end quote. During a presidential debate on September 29th of 2020, he refused to denounce white supremacists and violent extremists, instead told the Proud Boys to, quote, stand back and stand by, end quote. Later adding, quote, somebody's got to do something about Antifa and the left, end quote. Trump's words, stand back and stand by, were well received and considered an endorsement. So, one footnote that she does include here, that I had missed, was footnote 13. So she does have an extra note she wants to add. The court acknowledges that the statement occurred during a debate when the moderator had asked Trump to ask white nationalists and militias to stand down. And further, the President Biden called on Trump to disavow the Proud Boys specifically. Nevertheless, Trump's conduct is consistent with the pattern identified by Professor Simi in that an apparent disavowal, though the court notes the stand back and stand by does not carry the same meaning as stand down, was immediately qualified by an apparent endorsement that somebody has got to do something. So those two things go hand in hand. In fact, the Proud Boys turned the phrase into a mantra and put it on merchandise. The Proud Boys and other extremists understood this was a directive to be prepared for future violence. He said the looters will be shot when he becomes president again at the Iowa rally. Exactly, Roberta. It's starting again. I mean, and what this expert was saying is that this is part of this code that is inciting violence if you are a political extremist. Also regularly endorsed cultivated relationships with incendiary figures connected to far right, like Alex Jones, Steve Bannon, Roger Stone. Again, we're quoting the transcript here. Pearson, a senior advisory who helped organize, testified that Trump, quote, likes the crazies, end quote, referring to individuals like Alexander and Jones, whose speeches are often incendiary and inflammatory, who viciously defend him in public. So she was calling Jones and Alexander flamethrowers and agitators who want to get everybody riled up. Very true. I think those are accurate representations, is what I'm saying. He retained Bannon and Stone as advisors, two individuals with very close relationships with far-right extremists. Trump did fire Bannon. He would eventually issue a presidential pardon to him. Regardless, the court finds that Trump had courted these fringe figures for many years through activities such as endorsing far-right conspiracy theories like birtherism. So this is a finding of the court. She found that he had been courting these people. October 30th of 2020, a convoy driving dozens of trucks surrounded the Biden-Harris campaign bus on the Texas highway, tweeted a stylized video saying, I love Texas. So many of you might remember that she's hitting point by point everything that was raised in the petition. On November 1st of 2020, in response to the news the FBI was investigating the incident, Trump tweeted, quote, "In my opinion, these patriots did nothing wrong," end quote, and indicated they should not be investigated. Later that day, at a rally in Michigan, Trump again celebrated the incident, boasting, quote, "They had hundreds of cars, Trump, 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 and the American flag," end quote. Next, at no point did Trump ever credibly condemn violence by his supporters, but rather confirmed his supporters' violent interpretations of his directives. Professor Simi testified that through these repeated interactions, Trump developed and employed a coded language based in doublespeak that was understood between himself and far-right extremists, while maintaining a claim to ambiguity among a wider audience. I think this is so powerful, this particular piece of that, to give acknowledgement to what's really going on. For example, violent far-right extremists understood that Trump's calls to fight, which most politicians would mean only symbolically, were, when spoken by Trump, literal calls to violence by these groups, while Trump's statements negating that sentiment were insincere and existed to obfuscate and create plausible deniability. Is incitement to violence a crime in the U.S.? Yes, it is. Yes, it is. Yep. And then the court finds... knew his violent supporters understood his statements this way. Trump knew he could influence his supporters to act violently on his behalf. At this point, Trump isn't technically on the ballot. Yeah, exactly. I mean, it's all about the voting. It really is. The court notes Trump did not put forth any credible evidence or expert testimony to rebut Professor Simi's conclusions or to rebut the argument that Trump intended to incite violence. So I thought that was incredibly important testimony there that the judge found to be very helpful. All right, here's the next one. C, Trump's false allegations of this. So I need to watch my wording on this just so that I don't get dinged on the algorithm here. So Trump planted the seed well before the 2020 situation that any loss would be fraudulent. He portrayed it as being stolen in a way that resonated with the far-right extremists and aligned with their perspectives, that there's this corrupt system that's preventing them from electing somebody that they support, that the system is rigged. And again, she's pulling from the direct transcript here. Next, at an August 17, 2020 campaign rally in Wisconsin, Trump said, quote, "The only way we're going to lose this is if it's rigged. Remember that. It's the only way we're going to lose this. The only way they're going to win is that way, and we can't let it happen." I mean, that language is so, come on. We're not even hiding it. Right? We're not even hiding it anymore. So he's saying if he loses, then it must be rigged. That's the only way that he could lose. And people believe it. And that's what the judge is saying here. Yes, he's continuing. It's the same strategy. October 24th, 2020, Republican National Convention called mail-in voting the greatest scam in the history of politics, accused Democrats of stealing millions of votes, and argued the only way that they can take this election from us is if it's rigged. So that language just continued on. When asked at the White House press briefing whether he would commit a peaceful transfer of power, he refused. On November 2nd, the day before this kind of day, he criticized the U.S. Supreme Court for allowing Pennsylvania to extend the time for receiving mail-in ballots, stating the court's decision was, quote, "very dangerous, will allow for rampant and unchecked cheating, and will undermine our entire system of laws, and will also induce violence in the street, imploring that something must be done." Again, just using that language to kind of ramp up the whole situation. It worked for him. Yes. Oh, my goodness. All right. So on the night itself, he claimed victory, asserting from the White House this statement: "This is an embarrassment to our country. We're getting ready to win this. Frankly, we did win this. We did win this." Again, that language is being used, that coding language. On November 4th, Trump tweeted, "We are up big, but they're trying to do this with that. We will never let them do it." On November 5th, Trump tweeted, "Stop the count." Now, again, why would you want to stop a count, right? If you're saying not everything was counted, why would you want it stopped? I don't know, but I'm just putting that out there, my 2 cents worth. Yes, my moderators are amazing. Thank you, moderators. You're wonderful. On November 7th, the election was called for Joe Biden. On November 8th, he tweeted, "We believe these people are thieves. The big city machines are corrupt. This was a stolen situation." Best pollster in Britain, that's, not the US, wrote this morning that this clearly was this, which it was not. Trump's advisors within his administration, his campaign, and his legal team repeatedly told him he had virtually no chance of victory and that there was no evidence of widespread this sufficient to change the results. Despite his advisors telling him there was no evidence, he continued to maintain the election was stolen. Yes, I do kind of watch out for certain words. I found if I say certain words too many times, I get dinged, and I don't want to get the live pulled. Trump filed 62 lawsuits. 61 were rejected outright. I highlighted this in green because it's just fact. All right. He put forth no evidence at the hearing that he believed his claims of this were, despite the overwhelming evidence that there was none. The court finds that he knew his claims were false. So this is another finding. So she found he knew they were false. It went on nevertheless. On December 13th of 2020, he tweeted, "Swing states that have found massive this, which is all of them, cannot legally certify these as complete and correct without committing a severely punishable crime," end quote. December 14th, the college met and cast their votes in this election. The certified electors did this as follows: 306 for Joe, 232 for Trump. In the certified college votes were then submitted to Congress. Trump further sought to corruptly overturn the results through direct pressure on Republican office holders in various states, both before and after the college met and voted in their respective states. So we have a judge saying he intentionally tried to overturn the results and how he went about doing it. So I think that's very important. Time for a tea break. One moment, please. Okay. Next, many of the state officials targeted by Trump's campaign of intimidation were subject to a barrage of harassment and violent threats by Trump supporters, prompting Georgia election official Sterling to issue a public warning to Trump to stop inspiring people to commit potential acts of violence or someone's going to get killed. I thought the 14th was the defendant's responsibility to show no culpability in an insurrection. We'll get to that. She's setting out the facts here. And as she had set out very early, she said she was setting this up for the Supreme Court in Colorado. So she's including a lot of information here, not just the legal arguments. Because again, she doesn't want to have it sent back down to her to make another decision and then have it sent back up. Many of the states here, okay, I already read that part. Trump saw and retweeted a video of the press conference with a message repeating the very rhetoric Sterling warned would cause violence. All right, far-right extremists understood Trump's refusal to condemn the violence cited in the video, and his double down on the motivation for the violence was an endorsement of the use of violence to prevent the transfer of presidential power. Trump propelled the Stop the Steal movement and cross-country rallies in a lead up to January 6th with continued false assertions of this. Between Election Day 2020 and January 6th, Stop the Steal organizers held dozens of rallies around the country, inflaming Trump supporters with disinformation and recruiting them to travel to Washington, D.C. on January 6th. The rallies brought together many groups, including violent extremists such as the Proud Boys, the Oath Keepers, the Three Percenters, QAnon conspiracy theorists, and white nationalists. Is that Justice Sotomayor? Hello, good evening. These same Stop the Steal leaders joined 2 million MAGA marches in D.C. November 14th and December 12th. Tens of thousands of Trump supporters attended the events, with protests focused on the Supreme Court building. After the November rally turned violent, Trump acknowledged his supporters' violence, but justified it as self-defense against Antifa scum. Far-right extremists understood Trump's statement as another endorsement of the use of violence against his political opponents. Oh, my goodness. As the crowds gathered in D.C. on December 12th, Trump publicly assailed the Supreme Court for refusing to hear his fictitious claims of this. Stop the Steal organizers Alex Jones, Owen Schroer, and Ali Alexander understood his communications as a call to action, and thereafter led a march on the Supreme Court when the crowd chanted slogans such as Stop the Steal, 1776, which was actually not a very good year for, the common person, our revolution, and the fight has just begun. During the November rally, Trump passed through the crowd in his presidential motorcade. Then on the morning of December 12th, he tweeted, "Wow, thousands of people forming in Washington, D.C. for Stop the Steal. Didn't know about this, but I'll be seeing them. #MAGA. We saw their comments in our TikToks. We knew they were planning. Yes, and they go into that. Oh my gosh, she even goes into that. How notice was given. Later that day, Trump flew over the protesters in Marine One. He sent a tweet at 1:42 a.m. on December 19th, urging his supporters to travel to Washington. Statistically impossible to have lost this. Big protest in D.C. on January 6th. Will be there, will be wild. I want to know what his statistics background is. I'm just curious. I'm just wondering. Trump's plan was that when Congress met to certify the results, Vice President Pence would reject the true electors that voted for Biden and certify a fake slate, or return the slates to the states for further proceedings. Again, this question of, well, why can't we just ask them to recount? It's like you don't have the authority to ask them to recount, so you're not allowed to. Under the 12th Amendment and the Electoral Count Act, electoral votes are sent to Congress for a joint session on January 6th. Congress counts the votes from the states. If representatives object to the counting from a state, they need a senator to join in the objection. If that happens, a joint session recesses and goes back to each chamber. The vice president has no role in the objection other than presiding over the proceeding. Again, another key piece that I think will be used extensively. The court finds, so we've got a finding here, on December 19th, tweeted statistically impossible to have lost this. Big protest again. Be there, will be wild. He knew he had lost, and he knew there was no basis for Vice President Pence to reject the state's lawfully certified electors. The court also finds that Trump's December 19th tweet focused the anger he had been sowing about this being stolen on January 6th joint session. The message he sent was to save democracy. His supporters needed to stop the January 6th joint session. That was his message that he conveyed. By the way, can I just say, he uses the term democracy. Does that mean I get to use it now instead of... As a lot of people are like, we're not a democracy. Like, well... I'm just putting that out there. Trump's December 19th tweet had an immediate effect on far-right extremists and militias, such as the Proud Boys, the Oath Keepers, and the Three Percenters, who viewed the tweet as a call to arms and began to plot activities to disrupt the January 6th joint session. Trump repeated his invitation to come to D.C. on January 6th at least a dozen times. January 1st, he retweeted, "The cavalry is coming, Mr. President, January 6th. Trump added a great honor." So let's bump down. I think this is fascinating, this footnote down here. A cavalry is an open-air representation of the crucifixion of Jesus. What? The court presumes that Ms. Kremer and Trump, when he retweeted the text, were referring to the cavalry or an army component assigned to combat missions that require great mobility. Dang. Okay. That's a lot. Yeah, it's a lot, everybody. That's a lot. Whew. At the same time, Trump continued to make false statements regarding fraud, fueling the fire of his supporters' beliefs that this was somehow stolen. On December 26th, he tweeted, if a Democrat president candidate had an election, this and this, with proof of such acts at a level never seen before, the Democratic senators would consider it an act of war and fight to the death. Wow, that language. Mitch and the Republicans do nothing, just want to let it pass, no fight. With this message, he justified an act of war by claiming that is what the Democrats would do, but asserting the Republicans were too weak. Federal agencies that Trump oversaw as the chief executive officer of the executive branch, including the Secret Service, identified significant threats of violence ahead. So this is where we get into the acknowledgement that they knew it was coming. Some people had a pretty good idea. Okay. So, including significant threats, including threats to storm the Capitol and unalive elected officials. Such threats were made openly online and widely reported to the press. Agency threat assessments stated domestic violence, extremists or militia groups. Yeah, they had t-shirts made. Planned for violence on January 6th with weapons, including firearms, enough ammunition to win a small war. FBI received many tips regarding the potential for violence following Trump's "will be wild" tweet. One such tip said, they think they will have a large enough group to march into D.C. armed and will outnumber the police so they can't be stopped. They believe that since this was stolen, it's their constitutional right to overtake the government, and during this coup, no U.S. laws apply. Their plan is literally unaliving. Please take this tip seriously and investigate further. Yikes. Nonetheless, Trump did not advise federal law enforcement agencies that in his speech on January 6th, he was going to instruct the crowd to march to the Capitol. As a result, law enforcement was not prepared for the attendees at the rally to descend on the Capitol. Trump knew that Ali Alexander and Alex Jones wanted to speak at the rally. Pearson and Kremer described those two as flamethrowers and agitators and want to get everyone riled up. Pearson called them crazies. Kremer's called them wackos. Tea break. Wackos, yikes. Well, Trump agreed they should not speak at the rally. There's no evidence Trump discouraged their attendance at the rally or their presence at the Capitol. In the early morning of January 6th, he tweeted, if Vice President Mike Pence comes through for us, we will win the presidency. Many states want to decertify and the mistake they made in certifying incorrect and even fraudulent numbers. The process not approved by state legislatures, which it must be. Mike can send it back. He tweeted, all Mike Pence has to do is send them back to the states and we win. Do it, Mike. This is a time for extreme courage. Seeing everything laid out in just bits. I know. Every time we go through it, it's a lot, everybody. It really is. But this judge really took the time to get to each one of these one at a time. The court finds. So here's the court's findings. Prior to the January 6th rally, Trump knew his supporters were angry and prepared to use violence to stop the steal, including physically preventing Vice President Pence from certifying the election. In fact, Trump did everything in his power to fuel that anger with claims he knew were false about having won, and with claims he knew were false that Vice President Pence could hand him the election. All right, subsection D, the speech on the ellipse. Tens of thousands of Trump supporters began gathering here. I probably will skip through a little bit of this because we've been through this speech also before. To enter the ellipse itself, attendees were required by Secret Service to pass through magnetometers. Now, hold on, there's an abbreviation for that, everybody. I've already forgotten it. And to be checked for weapons. Mags, they're called mags. That's right, mags, thank you. Boop boop speech. Oh yeah, you got it. It's the boop boop speech. Around 28,000 rally attendees passed through the security checkpoints to enter the ellipse. From only the attendees who went through the security checkpoints at the ellipse, Secret Service confiscated hundreds of weapons and prohibited items, 269 knives, blades, 242 canisters of pepper spray, 18 brass knuckles, 18 tasers, 6 pieces of body armor, 3 gas masks, 30 batons or blunt instruments, 17 miscellaneous items like scissors, needles, or screwdrivers. And those are the people that actually went through the mags. Yikes! About 25,000 additional attendees purposefully remained outside of the Secret Service perimeter at the Ellipse and avoided the mags. They formed into a large crowd that extended to the National Mall and Washington Monument. Those attendees were not subject to any security screening. Some members of the crowd wore tactical gear, including ballistic helmets like those worn by riot police, goggles, gas masks, armed gloves, tactical boots, earpieces with radios, military-grade backpacks, and additional gear unknown to police. Should I have some of this gear, everybody? I feel left out. Is this just what normal people had? Yeah, is this just laying around your house? My goodness. Oh my gosh, like I've got extra water in case the lights go out, but what? All right. Okay. Some attendees of the Ellipse event were armed. So despite knowing the risk of violence and knowing the crowd members were angry and armed, Trump still attended the rally and directed the crowd to march to the Capitol. Now, why would you need all of that if you're just going to walk? Yeah, it's a great question. Like, I mean, come on. Okay. The following excerpts are from a speech. Now, I'm not going to go through his speech again, but she is pulling out specific pieces of that. I got my toothbrush. Well, yeah, I'm like, I always need to be prepared, right? I mean, beef jerky, right? Granola, water. You got to make sure you're okay. You're climbing up a mountain, but I wouldn't wear tactical gear. All right, she's just quoting the speech again. I'm not going to re-quote the speech. All right. Go bag a cat carrier. Yes. Oh my gosh. Yes, indeed. We don't know what Travis had. Maybe Travis had everything or nothing. Maybe he had nothing and that's why no one could find him again. Much of Trump's speech was not in Trump's prepared remarks. For instance, Trump's speech called out Vice President Pence by name 11 times. The teleprompter draft of the speech released to the National Archives contained only one reference to the vice president. That's interesting. You know, I wonder if it would be worth it to pull that original speech, everybody, that was given to the National Archives. I'm making a note. I have a copy of the actual speech he gave, but I do not have a copy of the original. I wonder how that would compare. Original speech. So I'm just going to make a note to pull that. It's okay to have tactical stuff, but you know, if I'm going on a girls' trip to the Capitol to support a candidate, you know, I'm probably not going to pack a bazooka, you know what I'm saying? All right, that's just me. That's in my opinion, everybody. Trump used the word fight or variations of it 20 times during his Ellipse speech. The teleprompter drafted, thank you. The teleprompter draft contained only one mention of the word fight. Wow, now I'm really curious about that speech. Trump also repeatedly insisted the crowd cannot let the certification happen. And then there's a direct quote here, which I won't reread. Just zip ties. Yeah, I'd take zip ties. I mean, that's just in my purse, right? That's what everybody has in their purse. The only bazookas are gum. Oh my gosh, I love it. I love it. They had a guillotine. Come on, people. Oh my gosh. All right. The teleprompter draft contained no mention of the crowd needing to prevent something from happening. The statement that alleged this allowed his supporters to go by very different rules was not in the prepared speech. Oh, I love how she's contrasting this. Knowing many of the crowd were angry and armed, Trump called on them to march in the Capitol and vowed to join them. Rally attendees took Trump at his word and thought he would join them at the Capitol. Oh, yikes. The crowd at the Ellipse reacted to Trump's words with calls for violence. I'm hoping I'm in frame okay, everybody. I leave it up to you to make sure to call me out if it's not in frame. After Trump instructed his supporters to march to the Capitol, members of the crowd responded. Who brought wood to make gallows? Did we ever figure that out? Or did they tear trees down? Yes, perfect. Okay, thank you. Oh, thank you so much. Did they tear stuff down in order to make the gallows? I'm curious. You're perfect. Oh, thank you, thank you. Okay, good. Oh, good. I'm so glad. All right, so members of the crowd responded with shouts of storm the Capitol, invade the Capitol building, and repeated chants of take the Capitol. Lowe's. They got it at Lowe's. Like, did they get it delivered? Like, what happened? You don't just get wood to build gallows. I mean, that's 2x4s. Yeah, but I mean, where are you getting your 2x4s from? Yeah, I mean, that's like, is that quick thinking or pre-planned? I'm just saying, I'm just curious. All right, I digress, everybody. The gallows situation fascinates me. Probably brought in the back of the... Probably, but my goodness. Instacart. Probably DoorDash. Oh, TaskRabbit sent them. You have to laugh sometimes, everybody. If you can't laugh about gallows, what can you laugh about? It seems planned to me as well. It does. All right. Okay. Moving on. As Professor Simi testified, Trump's speech took place in the context of a pattern of Trump's knowing encouragement and promotion of violence to develop and deploy a shared coded language with his violent supporters. An understanding had developed between Trump and some of his most extreme supporters that his encouragement, for example, to, quote, fight, was not metaphorical, referring to a political fight, but rather was literal, a call to violence against those working to ensure the transfer of presidential power. Well, Trump's ellipse speech did mention peaceful conduct in his command to march to the Capitol. The overall tenor was that to save democracy and the country, the attendees needed to fight. That's a pretty big call. Home Depot had a sale. Oh my goodness. Trump understood the power that he had over his supporters. Kremer testified that when Trump does these speeches, he plays off the crowd, and they're very reactive. She also acknowledged that the rally attendees were there because they believed the lie. This had been that. Trump admitted his power over his supporters recently, and then she's citing an exhibit as well. The court finds that Trump's ellipse speech incited imminent lawless violence. This very specific finding is very important because that means the First Amendment does not apply. All right, that's the Brandenburg test, so we'll get into that. Trump did so explicitly by telling the crowd repeatedly to fight and to fight like hell, to walk down to the Capitol, and that they needed to take back our country through strength. He did so implicitly by encouraging the crowd that they could play by very different rules because of the supposed fraudulent situation. In the context of the speech as a whole, as well as the broader context of Trump's efforts to inflame his supporters through outright lies of this in the weeks leading up to January 6th, and his longstanding pattern of encouraging political violence amongst his supporters, the court finds the call to fight and fight like hell was intended as, and was understood by a portion of the crowd as, a call to arms. The court further finds, based on the testimony and documentary evidence presented, that Trump's conduct and words were the factual cause of and a substantial contributing factor to the January 6th attack on the United States Capitol. This is a huge finding for any lawsuits regarding any damage sustained by anyone during that situation. So remember, we've got a couple of different lawsuits going for congressional members as well as police officers and other people that were injured. This finding could be used in civil courts to show there has been a finding of that his words were the substantial contributing factor. So that could be very important. Just FYI. So if I was working on those lawsuits, I would definitely pull this. The officers, yes, there were officers. There were several people who were harmed. And she just placed it down here in black and white and said, yes, his conduct and his words were the factual cause of a substantial contributing factor to the attack. So she's just held him liable for it. All right, here's E, the attack on the Capitol. While Trump was speaking, large portions of the crowd began moving with purpose from the Ellipse rally towards the Capitol building. Around 12:53, they overran the United States Capitol police officers at a police barricade near Peace Circle, breaching the security perimeter. The Proud Boys, who in moments before led the mob with chants of 1776, led this initial breach. The PTSD has to still be there for some. Oh my gosh, absolutely. Absolutely. That doesn't just go away. I mean, that's forever. If you've ever been mauled by a crowd, that will never leave you, ever. Shortly before 1 p.m., Vice President Pence released a letter asserting that his role as presiding officer is largely ceremonial and dismissed the arguments he could take unilateral action. Can these rulings be used in the gag order cases? Absolutely. Yep. The big piece that the other side will argue is that this was too long ago. It happened too long ago, and that it's not related to specific people involved in the cases. Under secure could very well be. Could very well be. I mean, there's an entire new protocol that was set out after this. There was a huge report that was set out and a new protocol. All right, here we go. By 1 p.m., the mob had advanced to the steps, began attacking the officers. And I'll just kind of skim through some of this again. In bad security situations, mobs are scary. I agree, Joanne. I agree. I think for me personally, I unfortunately was also involved in a riot situation. And I think that was probably the most scared I've ever been. And I've been by myself in Manchester. I'm just saying. Tea break. Okay. Not that I don't love Manchester. Don't get me wrong, people. It's because I love Manchester. I was there by myself. Trump's speech ended around 1:10 p.m. Thousands marched towards the Capitol down Pennsylvania Avenue as Trump had instructed. The size of the mob grew by the minute. The mob occupied the entire West Plaza by 1:14. By 2:13, the Capitol was breached for the first time when the Proud Boys smashed a window in the Senate wing. Yes, it's Manchester, UK. It's a bit of a rough town, Manchester is. I mean, it's adorably rough, but it's a bit of a rough town. And the mob began entering the building. The Senate recessed at 2:13. House suspended debate and objections until at 2:18, halting the process of it. Is this unavailable to the public? No, it is absolutely available. You can pull this up online, download it yourself, download it, upload it, reload it, offload it, unload it. It's all available. Yep, the Colorado 14th Amendment case. You can pull it up just by putting that in. Come to London. Oh, I love my time in London, Deborah. I might need to do that. The mob moved immediately towards its target, the certification of the election, reached the House and the Senate chambers within minutes. Some members of Congress removed their congressional pins so they would not be identified by the encroaching mobs. That's what happened in the riot I was involved in. We had police officers who were told to cover their badges. That was the only way to kind of scrunch down so people couldn't see their uniforms and cover their badges. That was the only way to kind of survive it. Others prepared to fight off the mob. That's not going to work. The mob was armed with a variety of weapons, including guns, knives, tasers, sharpened flagpoles, scissors, hockey sticks, pitchforks, bear spray, pepper spray, and other chemical irritants. Oh, Deborah, that's so sweet. I might take you up on that. The mob also stole objects at the Capitol to use as weapons, including metal bars from police barricades, pieces of scaffolding. Wait, is that where they got the gallows? Did they steal it? Did they steal the scaffolding and make the gallows? They build the gallows on... Okay, I'm going to sign art on it. So, Cody, did they build it before they broke in or after? I'm curious. I don't know why I'm so interested in figuring out how they... Maybe, yeah, okay. I'm getting sidetracked. Apparently this is my... No, it was built and brought. Okay. The scaffolding was metal. Okay. Yeah. Yes, it was wood. 6 a.m. They built. Really? Oh my gosh. Okay. That makes a huge difference, doesn't it? If it's built before or after. Okay. Metal pipes. Ouch. Trash cans, batons, and riot shields stolen from law enforcement. The mob assaulted police officers defending the Capitol to force its way into the building. Just as a quick side note, if you've ever known police officers, and we've had problems, everybody has problems with police officers. I get it. But if you have ever spoken with or dealt with or worked with an officer who has been assaulted or had a piece of their gear taken from them, they are just absolutely traumatized by that. So that's a pretty awful situation. Throughout the day, police officers were tased, crushed in metal door frames, punched, kicked, tackled, shoved, sprayed with chemical irritants, struck with objects thrown by the crowd, dragged, hit with objects thrown by the crowd, gouged in the eye, attacked with sharpened flagpoles, and beaten with weapons and objects that the mob brought to the Capitol or stole on sight. It's pretty awful. 33 years retired. Yeah, I mean, it's pretty awful. That's who they go for first, whoever's in uniform, whoever has a badge. Police deployed tear gas, pepper spray, flashbangs, and loudspeakers with a pre-recorded message instructing the mob to disperse, but the mob defied those orders, remained at the Capitol. Yeah, from the police to heroes. Yeah, exactly. Yeah, the Law and Order party. I mean, that when you get a mob together, that's dangerous. I mean, that's a weapon. The mob itself is the weapon. Members of law enforcement feared for their lives as well as the lives of their fellow officers, the vice president, and the members of the staff inside the Capitol. The attacks were deadly, resulting in the death of Capitol Police Officer Brian Sicknick. Many other law enforcement officers were injured, some requiring hospitalization for their injuries. Even though not everyone in the mob was violent, officers were unable to escape or get reinforcements. Law enforcement could not differentiate between which members of the mob were violent and which were not, which was one of the biggest points. There was no way to really understand. Yes, and later there were many who did take their own lives, unfortunately. But I'm telling you, if you've, oh my gosh, I've worked with many officers who've been in really bad situations. It's absolutely will destroy you. All right, the mob site. The New York Times had an article on the gallows. I'll have to look that up. I'm fascinated by it because I think it really is something that's so traditional. It goes all the way back in time. Like how much have we really evolved, I guess is my question. The mob's size prevented the police from carrying out arrests for fear of the safety of officers and detainees, which is very typical in a mob situation. The mob's size prevented law enforcement from using firearms or employing lethal force. The chaos created by the mob made it futile for police to call for help when they were individually under attack. And that's what you do. The crowd will separate each officer from the other officers. The mob's size made it impossible for first responders to reach those in medical distress. And when the responders attempted to provide such aid, they were harassed by the mob and assaulted. So even the medical responders, the first responders and medical help were harassed and being assaulted by the mob. Sometimes I think we forget about that. 988 suicide and crisis line. Absolutely. So important. I think it's important. Yes, absolutely. Every time. So there is you can call for help. Absolutely. There are so many resources and your local resources as well. 3 solid hours. Yeah, I can't imagine. It is being in combat. So, all right. And then we were assaulting first responders in the presence of nonviolent members of the mob and so officers, if they can't identify who's being violent and who's not being violent, they're going to have to second guess everything that they're doing. Refused demands to leave contributed to these problems. The court finds, all right, so here's another finding, that by sending otherwise nonviolent protesters to the Capitol, thereby increasing the mob's numbers through his actions and words, Trump materially aided to the attack on the Capitol. So this is another incredible finding that could be used in any lawsuit as well. Members of the mob told mob told officers, Trump sent us. We don't want to hurt you, but we will. We're getting into that building. You look scared and you might need your baton. And take off your badges, take off your helmets, and show solidarity with we the people, or we're going to run over you. Do you think your little pea shooter guns are going to stop this crowd and it's going to turn bad, man? We have to get you out of here. The others are coming up from the back. The mob chanted, "Fight for Trump." The members yelled into bullhorns, "This is not a peaceful protest." And she's citing an exhibit here. These types of statements were repeated in multiple locations around the Capitol during the attack when the mob faced resistance from law enforcement. The mob referenced war, revolution, Donald Trump, and stopping this. Members of the mob carried flags from the Revolutionary War and the Confederate battle flag. Their flags and signs said, among other things, liberty or this. Oh my gosh, yeah, January 6th, forever. Certify honesty and overturn the Biden win. Pence has the power. Mike Pence is a this. Well, that's not nice. And then that rhetoric there, which I'm not going to repeat, evoking Trump's references to Republicans in name only at the ellipse speech. They chanted, "Fight for Trump, stop the steal," 1776. The crowd displayed makeshift gallows. All right, again with the gallows. I'm just, ugh. The mob taunted law enforcement, calling them traitors and suggesting that law enforcement was the problem. They yelled, "You swore an oath, oath breakers." They swore an oath to the Constitution. "You're on the wrong team. You're not wanted here. What about your oath? And you're going against our country." Yikes. Professor Simi testified that repeated references to 1776 revolution and the Confederate flag were consistent with far-right extremists' use of the terms as literal calls for violent revolution. The presence of weaponry and defensive gear among a significant portion of the crowd confirmed this purpose. The mob at times worked together. January 6th Senate report that Trump's counsel described as the staff report from the Senate, that was bipartisan report, described January 6th as the violent and unprecedented attack on the U.S. Capitol, the vice president, members of Congress, and the democratic process. That's not nice, Merch. Yeah, that's not. That's really not nice. And that the attackers were intent on disrupting the joint session, during which members of Congress were scheduled to perform their constitutional obligation to count the votes. Amy Kremer described the event as a horrifying event and an awful, awful attack on the seat of our democracy. So next, she's going to walk us through, oops, I flipped the page too soon. Okay, next, she's going to walk us through the tweet. So his reaction. The last piece, though, here states the court agrees with Congressman Buck and concludes that the attack was meant to disturb Congress's electoral vote count. Again, this is a key piece to the election case in D.C. All right, so let's walk through the chronological piece here of the tweets. All right, so let's walk through the chronological piece here of the tweets. An hour after he had been informed, he tweeted, "Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a corrected set of facts." A corrected set of facts, right? So that's not good. Not the fraudulent or inaccurate ones that they were asked to previously certify. USA demands the truth. Oh my goodness, Roberta, what a story. Oh my goodness. All right. The tweet, yeah, I've got to watch my words. I'm saying too many words, everybody. I got to pull my words out a little bit better. Sorry. The tweet was read over the bullhorn to the crowd at the Capitol. The court holds that Trump's 2:24 p.m. tweet further encouraged imminent lawless violence by singling out Vice President Pence and suggesting that the attacking mob was demanding the truth. So Congressman Swalwell interpreted the tweet as painting a target on the Capitol and threatening Vice President. Yeah, Vice President and their personal safety and proceedings. Again, I'll start pulling my words a little bit better. Sorry about that. All right. The court further holds Trump's 2:24 tweet caused further violence at the Capitol. And just an FYI, everybody, if for some reason the live does get pulled, which sometimes that can happen. I mean, I try my best to not have it happen. But if it does get pulled, I will go onto my YouTube channel to finish the live. I try to be careful. All right, so further holds Trump's 224 tweet caused further violence at the Capitol. Again, this is really important for those civil lawsuits. 2:25 p.m., the mob breached the Capitol and the East Rotunda doors. 2:25 p.m., Secret Service evacuated the vice president from his Senate office to a more secure location. 2:30, Officer Pingian was attacked by the mob in the courtyard. He was forced to the ground, had his baton stolen. Around the same time, Senate chamber and House floor were evacuated. 2:38 p.m., 3:13, he sent 2 tweets, both encouraging the mob to remain peaceful and stay peaceful and asking the mob to not hurt law enforcement. Neither of the tweets condemned the ongoing violence or told the mob to retreat. Yes. The mob's conduct after it reached the Capitol confirmed that its common purpose was to prevent the constitutional transfer of power by targeting Vice President Pence, House Speaker Pelosi. Immediately after the first breach of the Capitol at 2:13, the mob moved to the Senate and the House chambers where this was being debated. Pence and Pelosi were expected to preside. They breached the Senate gallery, and the mob made a concerted and violent effort to break into the House chambers. Other than sending the 2 tweets, which did not call off the attack, Trump did nothing between being informed of the attack at 1:21 and 4:17. Instead, Trump ignored pleas to intervene and instead called senators, urging them to help delay the count. When told the mob was chanting this phrase, he responded that perhaps the vice president deserved it. He also rebuffed pleas from Leader McCarthy to ask that his supporters leave the Capitol, stating, "Well, Kevin, I guess these people are more upset about this than you are." Here's another finding. So now we're going to really get into the multiple pieces of finding. Again, if it's highlighted in orange, it's a finding by the court. The court finds Trump, as the commander of the D.C. National Guard, had law enforcement entities at his disposal to help stop the attack without any further approval. So this is that key piece everybody says, that it was up to Pelosi. It wasn't. Trump could have redeployed the 340 National Guard troops already activated in Washington, D.C. to assist with traffic and other duties on January 6th. This group could have rapidly responded because riot gear was already stored in convenient locations near their places of deployment throughout the city. There's no evidence that Trump made any effort on January 6th to redeploy these troops to the Capitol once he knew the attack was underway. In addition to the 340 National Guard troops that had already been activated by traffic control. Sorry, everyone, I've got to check my other spot here. There we go. Traffic control duty, or his quick reaction force, once he knew about the... activated. Could you recap what this brief's about? This is the ruling out of Colorado for the 14th Amendment to have Mr. Trump taken off of the ballot. The onion keeps peeling. It does. All right. Trump could have ordered deployment of additional D.C. National Guard troops once he knew about the attack on the Capitol. He could have asked the government of Maryland. I think this particular paragraph is incredibly powerful, everyone. He could have asked the governors of Maryland and Virginia to authorize their state National Guards to help. He could have ordered the Department of Justice rapid response teams to the Capitol. He could have authorized the Department of Homeland Security's rapid response team, which could have deployed in a matter of minutes from the headquarters to the Capitol. Trump provided no evidence that he took any action to deploy any of these authorities after learning of the attack on the Capitol. The court finds Trump had the authority to call in reinforcements on January 6th and chose not to exercise it, thereby recklessly endangering the lives of law enforcement, Congress, and the attackers on January 6th. Finally, at 4:17, Trump called off the attack. He released a video in which he said, and I'm not going to go through and repeat that again, but he did release a video. The court holds that Trump's 417 video endorsed the actions of the mob in trying to stop the peaceful transfer of power. It did not condemn the mob, but instead sympathized with them and praised them. It did, however, instruct the mob to go home on 3 occasions, emphasizing to the mob that this was an order to be followed. The mob obeyed Trump's order. And there it is. Yeah, exactly. And the mob obeyed. Once he released that, they broke it up. So they were listening. The statement was understood as a clear directive to cease the attack. At 6:01 p.m., Trump tweeted again, "These are the things and events that happen when a sacred landslide is so unceremoniously and viciously stripped away from great patriots who've been badly or unfairly treated for so long. Go home with love and in peace. Remember this day forever." And we will. He was in control. Absolutely. And that's what the experts were testifying to. The court holds that even after the attack, Trump's tweet justified violence by calling the attackers patriots and continued to perpetuate the falsehood that justified the attack in the first place, his alleged sacred landslide victory. As Professor Simi testified, this after-the-fact tweet was consistent with Trump's pattern of communication related to political violence, which always ended with Trump praising the violence. The court finds that at 6:01 p.m., tweet is further proof of Trump's intent to disrupt the election this on January 6th. So we have our intent element. This can definitely be used again in the D.C. case, any of the civil lawsuits as well. The court heard no evidence that Trump did not support the mob's common purpose for disrupting the constitutional transfer of power. To the contrary, both his 4:17 p.m. video and 6:01 p.m. tweet support the opposite conclusion, that he endorsed and intended the actions of the mob on January 6th. So he endorsed and intended the actions that occurred. All right. So next up, so that's that. Everybody, we made it through. Reliving that again. A little PTSD for everybody. All right, so let's get into this next piece. So now she's going to get into the Secretary of State practices. All right, this is not as exciting, but very important. Tea break. Thank you. All right, so here we go. The Secretary of State is responsible for certifying the federal offices and the state offices on the ballot. So she's going to go into how the candidate's paperwork has to be verified. There are a couple of key pieces out of this particular section, though. The office has also kept ineligible presidential candidates off the ballot. One candidate, Abdul Hassan, informed the Secretary of State's office he did not meet the constitutional requirements for the presidency because he was not a natural-born United States citizen. The Secretary of State's office informed Mr. Hassan that he was ineligible, and a court affirmed that decision. That's the process in Colorado. The Secretary of State makes the decision, and then the court affirms it. And that's how it works in Colorado. Other presidential candidates were excluded from the ballot in 2012, 2016, and 2023 for the 2024 ballot because they failed to certify their compliance with mandatory federal constitutional requirements for the presidency by completing the required paperwork that would otherwise attest to their qualifications. So they were disqualified because they didn't fill out the paperwork properly. Candidates or other who disagree with the Secretary of State's decision regarding whether to certify a candidate can challenge that decision in court. So ultimately, it's left up to the court. That's what she's putting in here. The Secretary of State's office creates the forms used by the candidates to access the ballot, including the primary forms. Here we've got major party candidate statements of intent for presidential and primary includes, among other things, check boxes to require the candidate to certify age 35 years, resident of the United States for at least 14 years, and a natural born U.S. citizen. But those qualifications are not the only qualifications for president. Candidates submitting this form must also sign and notarize the following statement. I intend to run for the office stated above and solemnly affirm that I meet all qualifications for the office prescribed by law. For instance, the Secretary of State would not permit a presidential candidate on the ballot who had already served 2 terms because that would be in violation of the 22nd Amendment. That is true despite there not being a box to check for the 22nd Amendment. When questioned by the court, Ms. Rudy testified that should the Secretary of State desire to do so, it would revise the statement of intent form and add the box confirming the candidate had not served 2 terms as president. She further testified that should President Obama seek to be on the presidential primary ballot, that was given it was an objective, knowing fact that he was not qualified, it's unlikely we would certify that candidate's name on the ballot. So again, explaining how their process works. And then bumping down again into more explanation of that. So the major party candidate wanted to put him on the ballot here. The documents contained in Exhibit 158 are facially complete, so they go into that a little bit more. She's holding, so the Secretary of State's holding onto the application in order to get an order from this court, and then she will proceed forward with that. Required to certify the candidates who will be listed in the 2024 presidential ballot. Again, this is Colorado law. It's different than Minnesota and Michigan. Secretary does not certify candidates individually. Rather, she certifies the entire contents of the ballot at once. The Secretary intends to certify the entire presidential primary ballot on January 5th. So here comes her conclusions of law, everybody. So we've set out all the facts. Now we're going to get into the conclusions. I'm going to be skipping through this because there are really just a few key pieces. She asks a question, she answers the question, she provides the evidence to support her answer. So we'll kind of climb through this next piece in that way. Conclusions of law. The court previously held that pursuant to this section of Colorado law, the burden of proof on this matter is a preponderance of the evidence. All right, that's a civil level of burden of proof. That is the burden the court has applied. However, the court holds that petitioners have met the higher standard of clear and convincing evidence. So she said, not only did you meet your burden of proof, you exceeded it. You actually went to the next level of proof. So I thought that was very important to note. Absolutely important. Everyone should know. Absolutely. All right, here's the first one. Can the Secretary of State exclude Trump from the ballot? So they're setting out the law here, again, stating that the inflammatory, oh my goodness. Oh my gosh. Okay, so setting out what the Secretary's role is here. So she goes into the law explaining that and going through the Colorado process. So after filing a verified petition, notice to the official includes multiple pieces as well. And let's see, if a court finds good cause to believe the election official has committed or is about to commit a breach or neglect of duty or other wrongful act, it shall issue an order requiring substantial compliance. So she's just saying the courts have the authority in Colorado to call the secretary out on this. So she's setting that into place here. The court's ruling in pending dispositive motions left for trial the issues of whether the General Assembly has charged the Secretary of State with the authority to investigate. Here, the interveners, so Trump and the Republican Central Committee, argue the Secretary's role is simply ministerial. They argue her responsibility is either to confirm a candidate has affiliated with the party or not. And what she's saying here is that's not true. That's not the power the Secretary has. She's setting out in Colorado, the Secretary of State has the authority to make this determination. But the next piece is preponderance of the evidence, same as reasonable doubt. No, I'm glad you asked. So preponderance of the evidence here is what we need in a civil court. So it means 51% liability. So whoever is 51% responsible is the responsible party. Beyond a reasonable doubt is what we use in criminal court. And it is a huge, huge standard. And it means that you can only have a tiny percent of doubt. So the best way that I try to explain it is usually, and this is how they explain it for civil cases actually, is they'll get a set of scales out and they'll say, if you just have a feather on one side, that's 51% at fault. How I put it is that there is a feather here for beyond a reasonable doubt, because if you have just a feather of doubt, that's not enough. You need to have something more than that. So just this is not enough in order to find that finding beyond a reasonable doubt. So if you want to put this into, this is a terrible drawing, everybody. If you want to put it into percentages, you want to say 98%, okay? So this feather represents 2%. You need to have a 2% plus of doubt. And then if you do, you can't convict. Is that making sense? Yes. So there you have it. There's my picture. That's my terrible picture. That's why I went to law school right there. It was discussed in another live. Oh, we love that. That's great. I think we should absolutely talk about these things so everybody can understand what's going on. I think that's so important. All right. So she's going through the analysis whether or not the Secretary of State can keep him off the ballot. Finally, here's her holding. The court holds the Secretary cannot on her own accord keep a candidate from appearing on the ballot based on a constitutional infirmity, unless that constitutional infirmity is an objective, knowable fact. So she's saying the Secretary of State has the authority to keep you off the ballot unless it's kind of this nebulous, odd constitutional question, which is what they're asking here. So if it's about age, if it's about if you're a natural born citizen, if you've been here 14 years, all of those kinds of things the Secretary of State has the authority to make. But if it's this question of, is it constitutionally okay for you to be there other than those clear specified facts, then it's outside of her realm. Plot twist. Here, whether Trump is disqualified under Section 3 of the 14th Amendment is not an objective, knowable fact. So that's the key. The key is the language. Can't act alone because of the nature of the issue here. The question then becomes whether petitioners can file this action here. So she goes into that a little bit more. Oh, thank you. I hope that it's fascinating. This whole opinion is actually very, very interesting. Petitioners argue that regardless of whether the Secretary has the power to investigate, the court should order the Secretary to bar him from the ballot. So they're using multiple pieces of case law again. So they're arguing back and forth. Does she have the authority? Can she take him off the ballot? The court is saying, I don't think she can because of this constitutional question, so I'm going to say no. And the petitioners are saying, but you can, so you should order her to take him off the ballot. So she came up with this next piece and said, the question before the court then, does the election code incorporate Section 3 of the 14th Amendment? That's the ultimate question, everybody. So this is the law in Colorado. All right. So what she's saying is this federal constitution section, is that incorporated into our state law? So I think that's a great question. Ms. Rudy testified the Secretary had previously kept candidates off that didn't meet the requirements of Article 2. So this is at 35 and where you've been born. She further testified the Secretary would likely enforce the 22nd Amendment, meaning the 22nd Amendment said you can't run more than twice. So while the court agrees with the interveners, the Secretary cannot investigate or adjudicate Trump's eligibility under Section 3 of the 14th Amendment. The election code gives this court that authority. So she's saying the Secretary does not have the authority to investigate if there has been an insurrection or if he's disqualified, but the court has the authority under the law. So I think that's pretty significant. So Secretary, no, court, yes, is how that came out. Okay, everybody, you're going to have to give me 1 second. I need to go grab my battery pack. So just a minute. I know we're kind of turning a corner here, but I got to get my battery pack. Okay. Elevator music, yes. All right, this might bump you off just for a second, but I'll be right back. Oh my goodness. Okay, we're back. Here we go. Usually I'm better prepared than this, but I grabbed the wrong thing. I really need to get schooled on how all this computer stuff works. All right. Let me make sure I'm okay for my frame. Take a drink of tea. Okay, so the next part here does go pretty quick, so I'll kind of be skimming through this. It's askew. Okay, hold on. It might be me that's askew. Here we go. I have my danger zone sign so that I can kind of stay in frame. The camera is askew. Is it still askew? I think I just switched it. All right, is it back? Okay. If he gets found to be ineligible and hold office in one state, does that hold to be true for all states? No. It'll be a state-by-state situation. I love the word askew. Yay! All right, everybody. So, where were we? Okay, so she said Secretary cannot investigate Article or Amendment 14, Section 3. Courts can. She's backing up with case law here. So next, did President Trump engage in an insurrection? So this is very important. Section 3 of the 14th Amendment, passed in 1866, ratified by the states in 1868. So no person shall be a senator or representative in Congress or elector of president or vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may be, by a vote of 2/3 of each house, remove such disability. Oh, thank you. So that's the language. She relies very heavily on this language, so I think it's important to go through. All right, so let's see. Let's see where her analysis is going. Section 3 of the 14th Amendment was primarily written to prevent officials who left to join the Confederacy from returning to office. So that is why that piece was written. So when many former Confederates sought to be seated as if nothing happened, Republicans in Congress found it necessary to act to exclude them from positions of authority unless they demonstrated repentance or deserved forgiveness. So there were a lot of debates involved as well. Next, let's talk about the oath. The oath is central to Section 3. It served as a limiting function because Section 3 only applies to those who had betrayed a previously sworn oath to the Constitution, which included those most responsible for the Civil War. Supporters of Section 3 believe that such oath breakers could not again take office and swear an oath without committing moral perjury. Did you hear Floyd's bond revocation hearing is tomorrow? No, I didn't. Oh, good to know. Good to know, Sarah. Thanks for telling me that. All right. The history of Section 3 and its passage indicate that provision is not limited to the events of the Civil War. The language of Section 3 refers generally to insurrection or rebellion. The senators in the debate made clear their intent for it to apply to future insurrections. Could the judge have skipped this question and just said the 14th doesn't apply? She could have, but what she wanted to do was she didn't want to leave any questions unanswered for the Supreme Court. She didn't want the Supreme Court to come back and say, we've got to send this case back down to the judge because she didn't make a proper determination on something. So she determined everything so that they had all the information they need. Will Congress decide this then? Well, we will see. We will see. So in the years following the ratification, she goes into the history a little bit more. I'm going to kind of skip through just a little bit. I've pulled out what I think is the most important piece, so I'm not going to read every single word. Yeah, I mean, 1776 was a rough year. I don't think they really realized that, actually. There was a lot. All right, Section 3 qualifies insurrection by the phrase against the same, referring to the Constitution of the United States to which the oath was sworn. That limits the scope of the provision by excluding insurrection against state or local law and including only insurrections against the Constitution, which officials have sworn an oath to support and have now broken. So here's how she's defining insurrection, and I think she's absolutely correct. As the Supreme Court declared during the Civil War, quote, insurrection against a government may or may not culminate in an organized rebellion, but a civil war always begins by insurrection against the lawful authority of the government. So that's the Civil War case directly citing what exactly an insurrection is. So you don't have to have a civil war to have an insurrection, but you have to have an insurrection to start a civil war. Very interesting. The court finds an insurrection at the time of the ratification of the 14th Amendment was understood to refer to any public use of force or threat of force by a group of people to hinder or prevent the execution of law. So that is the definition. All right, so here we go. And then she goes into a little bit more of an explanation of insurrection here, which I'm not going to spend a lot of time on because she's also comparing it to the language of today. We do have a case out of 2023 that I think is important here. When interpreting the text of a constitutional provision or statute, courts often resort to contemporaneous dictionaries or other sources of context to ensure that we are understanding the word in the way its drafters intended. So that's important. And then she goes through into the dictionary. They had multiple people coming and testifying about dictionaries. So I think that was important for her. Could you read that definition one more time? Sure. And this is the case, everybody. This is the case. It's called the Amy Warwick case, and it's a case out of 1862. This is the citation, so you can pull this case yourself if you're interested in that. Declared during the Civil War, an insurrection against a government may or may not culminate in an organized rebellion, but a civil war always begins by insurrection against the lawful authority of the government. He was on the way out. Yeah, he said goodbye. He had a flight to catch. Yes. So, very, very interesting. I mean, and it's completely correct, I think, with how the court defined it there. All right. Trump's expert witness here offered an opinion the meaning insurrection at the time was less clear. However, he did not identify any historical sources. So she dumped that. However, in the context of Section 3, and in accordance with the historical understanding, the court finds that such insurrection must be against the Constitution of the United States and not against the United States, as the interveners would suggest. This is one of those huge questions that was being asked. Is it an insurrection against the United States government or against the Constitution? She's saying it's the Constitution. So she's setting that line. Considering the above in the arguments made at the hearing and in the parties' proposed findings of facts and conclusion of law, the court holds that an insurrection was used in Section 3 of the 14th Amendment. How long and how many staff people does it normally take to write this? You know, I had wondered why it had taken so long for it to come out, because it took like 2 weeks, I think, for it to come out, and I can see it took so long because she was so thorough. I have no doubt that that she wrote this, but it was she had assistants to do it. But I don't doubt these are her words. Yes, exactly, because it was so well written. And I think this was a very important point for her. I don't think you would have gotten something like this from a clerk. The other thing, if you think about it, even with a jurisdiction the size that she is ruling in, she would not have the kind of staff that even the next higher up, the Court of Appeals or the Supreme Court in Colorado would have. She probably doesn't even have staff that could have come in and written this. Yes, she does. She does talk about the difference between an insurrection and a protest. So the court holds that an insurrection as used in Section 3 of the 14th Amendment is 1, a public use of force or threat of force, 2, by a group of people, 3, to hinder or prevent execution of the Constitution of the United States. Those are the 3 factors that set out an insurrection under the 14th Amendment. The court further concludes that the events on or around January 6, 2021 easily satisfy this definition of insurrection. So no conviction is needed. There's a 3-part test. There are 3 parts. And if you meet those pieces, you have committed an insurrection. That's how the law works. So she has set that out. So here's the facts that support all 3 pieces. Thousands of individuals descended on the U.S. Capitol. Many were armed with weapons, prepared for violence. The mob was coordinated, demonstrated a unity of purpose, which is very important. The mob's purpose was to prevent the execution of the Constitution so that Trump remained president. In this, she opened the door for Jack Smith to still charge him with insurrection. I think that could already be on his agenda. This does nothing but help. Would be just another pillar to help support that. But I think if that's already in his master plan, that'll take its form at the right time. All right, the mob's purpose, again, prevent the execution of the Constitution, so he remained president. So specifically, the mob sought to obstruct the counting of this and set out in the 12th Amendment and thereby prevent the peaceful transfer of power, so which is what he's charged with here in the D.C. case. All right. Would love to see that superseding indictment charging him. Yes, I have no doubt there is the master plan. There's more to come. All right, now we get into the definition of engaged. I'm not going to spend too much time on this particular piece, but she does go into whether or not there was engagement. And Trump's primary argument that incitement fails to meet the constitutional standard of engagement stems from the Second Confiscation Act passed in 1862. In that act, among other things, it made it a crime for a person to incite, set on foot, assist, or engage in any rebellion or insurrection against the authority of the United States or the laws thereof, or shall give aid and comfort thereof, blah, 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 blah. The argument generally is that the Second Confiscation Act distinguished between incitement and engagement. So I know I blah-blahed the rest of this, but we're moving on. By virtue of listing them separately, thereby suggesting that they were understood to be separate activities. He further argues Section 3 of the 14th Amendment was patterned in part on the Second Confiscation Act based off of the qualification. Lastly, he's arguing certain cases in Congress in 1870 suggested that congressional understanding of Section 3 did not include incitement as engagement. So saw those as 2 separate things. The petitioner's argument on this subject is essentially that constitutional amendments generally are less granular than criminal statutes, and so it's not surprising or determinative. Section 3 provided only for engagement and did not specify incitement. Further, evidence of the application, interpretation, and enforcement in the term engage as used exists suggest a broader definition that encompasses incitement. So let's bump down here. So those are the big arguments that he presented. Having considered these arguments, the court concludes that engagement under Section 3 of the 14th Amendment includes incitement to insurrection. The court has reviewed the Congressional Globe and Hines' precedents regarding the cases of Representatives Rice and McKenzie cited by Trump and finds that they offer little to no guidance on the question before the court. Yes, we don't do conspiracy theories here. There are lots of other fun, original creators that you can go and join and talk about conspiracy theories all to your heart's desire. We just do not do that here. Both cases concern fact questions as to whether representatives provided aid or comfort to the enemies. So she goes into that a little bit further. Similarly, the court has reviewed the congressional cases the petitioners cite and finds that they too are inappropriate and therefore unhelpful. Yes, please don't argue with my moderators. They work so hard. Further, the court is not convinced that the Second Confiscation Act compels the conclusion that Congress deliberately omitted other distinct unlawful acts, such as incitement, by requiring only that a person shall not have engaged in insurrection or rebellion. So I found this judge started to crack me up a little bit, so I made little notes here. The court finds that this has a limited utility interpreting the Section 3. So she's saying there's sources that that Trump was citing were not helpful. So she's saying, I've looked at the law, I've looked at the facts, your arguments aren't that strong. The court finds more persuasive, and this is the key, the opinions of the Attorney General Stanbury, which adopted an unequivocally broad interpretation of engagement in insurrection. So, on the subject, he opined that an act to fix upon a person the offense of engaging in rebellion under the law must be an overt involuntary act done with the intent of aiding or furthering the common unlawful purpose. That's the standard that she's using. Specifically, as it relates to an incitement, he opined disloyal sentiments, opinions, or sympathies would not disqualify, but where a person has by speech or by writing incited others to engage in rebellion, he must come under the disqualification. So that's pretty substantial finding here. She's citing not only the Reconstruction Acts of 1867, but she's also pulling from a case, U.S. v. Powell. Is promising a pardon if elected, giving aid to the enemy. I'm not sure that the promise itself would necessarily be seen as given aid, because the promise could be broken. I think the act itself could be considered it. All right. So we've got case citations as well. Let's see. So then she comes in with her further analysis. Random question, but why are they citing McCulloch and Maryland? Why are they citing McCulloch and Maryland? Oh, let me pull it. Here we go. All right. So constitutional provision, it says naturally must receive a broad and liberal construction. So McCulloch versus Maryland is one of the original cases decided by the U.S. Supreme Court involving a bank. And so in this particular case, I think what they're trying to say here is how you interpret the language of the Constitution. So that's why they're citing it, because that's one of the earliest cases going through the actual literal language of the Constitution. And it was overturned. So we don't have a bank anymore, a national bank. Great case, though. All right, here we go, everybody. Staying on target. Is there a document like this that explains why Gates got off the trafficking? Oh, I wish. I wish. If anybody finds one, let me know. The precedent. Giving aid. Did she answer giving aid, or was it a question? So she'll go into it a little bit further. The precedent finding. She does go into it a little bit more. All right. So again, we're talking about the Reconstruction Acts. So here's what she's saying here. The court agrees that engage was not intended to be limited to the actual physical prosecution of combat, or likewise import a necessity that an individual take up arms. All right. So here, instigation and incitement are typically actions taken by those in leadership roles and not, for example, by those on the front lines with a weapon in hand. To exclude from disqualification such people would seem to defeat the purpose of disqualification, at least as it relates to potential leaders of insurrection. Yes, exactly. You got it, Suze. Yep. All right. And she's citing case law here. So I think she did a good job. She kicked out the defendant's argument here, and she properly cited precedent. Could Ginny Thomas potentially face similar charges? Maybe. As discussed below, the reason incitement falls outside the First Amendment protection is because of its quality of speech as action. So she's setting up this next piece because this idea that it's the First Amendment. So my speech was covered by the First Amendment. Incitement is not protected under Brandenburg, so she does go into that. Consequently, the court sees nothing inconsistent between a requirement that a person be affirmatively, actively involved in an insurrection to qualify as having engaged therein, and a finding that incitement qualifies as engagement. Andrew Jackson didn't fight in the Civil War. He just took the job. Yeah. True story, Daisy. True story. Number 3, does engage include inaction? So, we had our previous case where they had tossed out. So let me take a step back. So in the lawsuit where we've got multiple officers and multiple people who are suing Trump, one of the causes of action that they set out was because he didn't do anything. That was dismissed from that lawsuit, but she gets into that here, and she says in this particular situation, we've got a little bit different story. All right, so does engagement, sorry everybody, I'm flipping, it's getting late. I can tell my brain's starting to slow down a little bit. That's all right, we'll get through it. They argue that Trump's intentional dereliction of duty was undertaken with the purpose of helping the mob achieve their goal of obstructing the certification, and is therefore independent basis for finding that he had engaged in the insurrection. The court holds it need not look further than the words of Section 3 to conclude that a failure to act does not constitute engagement. Here, petitioners do not argue that Trump gave aid or comfort to an enemy of the United States. The court holds that Trump's inaction as it relates to his failure to send in law enforcement reinforcements is not an independent basis for finding he engaged. So what she's saying here is by not acting doesn't necessarily mean that you didn't engage like the other courts did, but by itself is not enough. So that does not mean Trump's failure to condemn January 6th attackers at any point during the attack, his failure to tell the mob to go home for 3 hours, or his failure to send reinforcements to support law enforcement has no relevance. So she's not saying it's not relevant. To the contrary, the court holds that all 3 of these failures are directly relevant to the question of whether petitioners have proven the specific intent required under Section 3. So these pieces are important and essential elements to finding specific intent. Has been scrambling for years. True story, my friend. True story. How'd you know? All right, here we go. First Amendment application as well. We'll kind of skip through this again. I've done full lives on the Brandenburg test and explaining how inciting language is not covered. So we'll go through here. First Amendment's application. The defendants are arguing again. This is core, pure speech. It should be allowable. The petitioners are saying here that it wasn't just speech. It was the conduct as well. And the First Amendment protections are not in place for that. So they go through that. Now, she sets up 2 subcategories here. First is the legal backdrop to the First Amendment case. So we've got the Brandenburg test. So the court starts with the Brandenburg test, it being the central case at issue in providing the namesake to the test the court is to consider employing. So she explains the Brandenburg case, right? So I've done a lot of posts on Brandenburg. This is where a reporter showed up at a rally and, filmed stuff, and people were really upset about it. And they're saying here it was freedom of speech to hold this rally. And so what happened was they set out a test and they said, is your speech inciting imminent lawless action? And if it is, then it's not protected. But if it's not, like here, they were just showing pictures, then it is protected by the First Amendment. Okay, so skipping through Brandenburg, not because it's not important, but because I've talked a lot about it before. Next, almost a decade later, Supreme Court considered the intersection of the concerted political action and violence in National Association for the Advancement of Colored People versus Claiborne Hardware Co. So this is, I guess you would say, Brandenburg's partner. So the 2 cases that set out this imminent lawless action doctrine, this is the second case, considered a boycott of white merchants in Mississippi, which began in 1966. So again, there was a lot of language that was used for this boycott, and the question became, was the language being used protected or not? The Supreme Court found in that case, through speech, assembly, and petition, rather rather than through riot or revolution, petitioners sought to change a social order that had consistently treated them as second-class citizens. So here, they recognized that these activities are constitutionally protected. The Mississippi Supreme Court's ruling was not predicated on the theory that state law prohibited nonviolent, politically motivated boycott, but rather on the theory that it had constituted an agreement to use violence. So that was another situation where we're setting out imminent lawless action is not covered by the First Amendment. So bumping down, here's the ultimate holding. The Supreme Court found that the speech that was given about this boycott did not meet the standard for it to be an imminent lawless action, emphasizing the distinction between mere advocacy for violence in the abstract, which is afforded protection, and incitement. The Supreme Court found the ever speech generally contained an impassioned plea for Black citizens to unify, to support and respect each other, and to realize the political and economic power available to them. So strong language was used, but this was not one of those imminent lawless action situations. So that's the second case. Again, and I'm just kind of giving you a quick overview of those cases. You can pull them. You can actually search Brandenburg if you're interested. I've got a whole series of videos on it. So next she goes into, does the Brandenburg test apply? So was this speech imminent lawless action? Got me thirsty now. Yeah, I know. You got to go get it. Go get it. With respect to petitioners' argument that their request for relief is based on conduct and not speech, the court disagrees. All right? The court has already ruled on the argument that Trump's inaction constitutes engagement. Further, the conduct leading up to the events of January 6th are predicated on public speeches and statements and therefore are appropriately analyzed as speech. So she disagrees. She says it's not conduct. It is speech. And that speech is not protected. So they also go into their second argument as well, and I'm not going to spend a lot of time on that either because I really want to get to the court's holding here. While the court believes that there's certainly room to distinguish the conduct at issue here, the conduct at issue in this other case, and does not suggest the factual circumstances between the two cases are at all similar. So she's really relying on the Brandenburg test here. Brandenburg-related cases are clear. In order for speech to lose its protection, it must cross the threshold from abstraction to action. It must be used as a means of force, not a means of contemplation of advocacy. That's the test. All right, everybody? So Brandenburg, imminent lawless action. And we're not just contemplating this, we're actually taking it the next step into action. After going through this, I've changed my mind. Well, Sarah, there's just a lot to it. And the more you look into it and peel it apart, the more you can see that it's not as simple as we had originally thought. All right, so speech constitutes an integral tool in furtherance of a lawless act and loses its distinction and becomes an instrument of force. And this is out of a very famous case here. So next, applying the Brandenburg standard to the questions of incitement as engagement, even in the context of elected officials and loyalty oaths, ensures a mere disloyal sentiments, opinions, or sympathies do not result in disqualification. So only just being disloyal or having opinions or being sympathetic is not what's going to disqualify you. It ensures that elected officials are afforded the appropriate breathing space to discuss public policy. Therefore, that the petitioners are seeking Trump's disqualification on the basis that he engaged in insurrection through incitement, it must be proven that his speech was intended to produce an imminent lawless action and was likely to do so. So she's saying, hey, is that what his speech was intended for? So let's take a look here. She's going to go through, she went through Trump's request for a directed verdict, and I'm going to kind of skip through that because it doesn't really go into much of the analysis very much. But she comes back in here and cites the Claiborne hardware case again. To assess whether Trump intended to produce disorder and whether his words were likely to produce disorder, the court must consider his knowledge or understanding of how his words would be perceived by his audience. Such an inquiry requires the court to consider the history of Trump's relationship to and interaction with extremist supporters and political violence. So that's a huge piece. The court addresses the issue of the intent required to establish incitement. The court finds that the specific intent necessary to sustain a finding of incitement is likewise sufficient to sustain the intent required by Section 3. So she found specific intent for the incitement, and therefore that same intent transfers over with what's required under Section 3. Now, I particularly like that she cited the Counterman versus Colorado case, which was decided just last year by the U.S. Supreme Court last session regarding, is a threat something that because the victim hears it, or is it because the person saying it knows it's a threat? So that's kind of that interesting standard that got set out here. All right, now we're going to really get into the final pieces here, everybody. We're coming down to the finish line. So for this court to find Trump incited an insurrection, the court must first find that he had specific intent, either purpose or knowledge, to produce the insurrection. A finding that Trump had the purpose or knowledge for producing the insurrection is sufficient to satisfy the requirement that he engaged in insurrection through an intentional act. Can this be admitted as an exhibit to the DC trial, or is it hearsay? I'm not sure how or why you'd be able to actually get this in. It would be good to use they could use it as a resource or inspiration, but I'm not sure this would be something that would be able to be used in court, because I'm not sure what the relevance would be, because we've got to have our jury find each piece of the elements on their own. We wouldn't want prior decision to come into play for the jury. It's a good question, but this is better as reference material. All right. And because, too, you wouldn't want a jury to say, well, this court held this way, so we should hold this way, too. We want to keep them very independent so that they're kind of set apart. When are we going to see the merch? Oh, my gosh. The merch train slowed down, everybody. I got to get back going. Oh, my gosh. I got to get back on. Yep. All right, application of the Brandenburg test. So the court concludes, based on its finding of facts in the applicable law detailed above, that that Trump incited an insurrection on January 6th and therefore engaged in an insurrection within the meaning of Section 3 of the 14th Amendment. First, the court concludes that he acted with specific intent to disrupt the certification. You could get the judge to be a fact witness. Perhaps, I'm just not sure how her testimony would be relevant. They have to prove each of the elements for what he's been charged with in D.C., and I'm not sure how she would be involved in that. Does a good job of thinking through all possible arguments and ruling on them. Exactly, Georgie. That's exactly right. She gives both sides all of the arguments and what it was that persuaded her. So they could go down the same road of what persuaded her and look at, well, could this persuade a jury? So she's setting out, I really thought that this professor did a good job, and this is why. So that same kind of information could be used in the DC case and could be very helpful, because if it helped a judge come to her decision, it certainly is going to help a jury. So kind of as a reference, as a background, a strategy. Next, the court concludes the language Trump employed was likely to produce such lawlessness. So, yes, there was an insurrection, and he knew that it would love me 10 years ago. Oh, my goodness. Oh, well, I'll take that as a compliment. I don't know who you are, but thanks. Regarding Trump's specific intent, either purpose or knowledge, the court considers highly relevant Trump's history of courting extremists and endorsing political violence. So here's the key to the whole case, everybody, in my humble opinion so far. As legitimate and proper, as well as his efforts to undermine the legitimacy of the results and hinder the certification of the college results in Congress. Trump's history of reacting favorably to political violence committed at his rallies or in his name, as well as his cultivation of relationships with extremist political actors who frequently traffic in violent rhetoric, is well established. Trump has consistently endorsed violence and intimidation as not only legitimate means of political expression, but as necessary or even virtuous. Further, the court has found that Trump was aware that his supporters were willing to engage in political violence and that they would respond to his calls for them to do so. In addition to his consistent endorsement of political violence, Trump undertook efforts to undermine the legitimacy of this well in advance of that, making accusations of widespread corruption, this and this. As the Electoral College situation was cast and the certification date drew closer, Trump further intensified his public efforts at disrupting the certification, even as violence, intimidation, and calls for political violence escalated. Trump continued to inflame his supporters with false accusations of historic levels of this kind of corruption, which led to January 6th. On the morning of January 6th, Trump focused the attention of his supporters on Vice President Pence and his role in certifying the results, falsely claiming Vice President Pence had the authority to send back the votes for recertification. Tea break! Time for tea. Okay, so he focused his attention on Vice President Pence. He continued to focus the crowd on Vice President Pence. After being informed of the attack, he did not do anything. So first he sent out a tweet condemning Vice President Pence. Later he sent out other tweets encouraging his supporters to remain peaceful. He resisted calls from advisors to intercede. It was not until 4:17 p.m. that he released a video that unmistakably called for the mob to disperse while simultaneously praising their conduct. He continued to praise the violent conduct of the mob after it dispersed. So, the court concludes Trump acted with specific intent to incite political violence and direct it at the Capitol with the purpose of disrupting the electoral certification. And then she sets out her support for that. When the violence began, he took no effective action, disregarded repeated calls to intervene, and pressured colleagues to delay the certification until roughly 3 hours had passed, at which point he called for dispersal, but not without praising the mob and again endorsing the use of political violence. The evidence shows that Trump not only knew about the potential for violence, but that he actively promoted it. And on January 6th, he incited it. So that's a key piece here. The court therefore holds that the first Brandenburg factor has been established. So you have to meet both prongs in order to say that the speech is not protected. So that's what she's going through here. I'm going to skip down a little bit again. She's going into that next factor of the Brandenburg test, and she is finding that second factor as well. So court finds the language that Trump used throughout January 6th was likely to incite imminent violence. So she's supporting that as well. So it's a pumpkin. It's an upside down pumpkin. Oh my goodness. All right. She goes, why Trump's opinion of this is incorrect. And I think it's important to see what her support is here. This argument, so he put his saying First Amendment campaign, sometimes the language gets that way. And she's saying this argument, however, ignores both the significant history of Trump's relationship with political violence and the noted escalation in Trump's rhetoric in the lead up to and on January 6th. It further disregards the distinct atmosphere of threats and calls for violence existing around this and its legitimacy. When interpreting Trump's language, the court must consider not only the content of his speech, but the form and context as well. So his speech isn't just normal political speech because of the history, because of his intent, and because of what has happened in the past. Consequently, the court finds the petitioners have established Trump engaged in an insurrection on January 6th through incitement, and that the First Amendment does not protect Trump's speech. All right. So everybody, we're coming down. We're coming down to the final piece here. Does Section 3 of the 14th Amendment apply to President Trump? So let's get into this part. The court holds that there is scant direct evidence regarding whether the presidency is one of the positions subject to disqualification. So this is the key. She's saying under the language of the amendment that president was not listed. The disqualified offices enumerated are presented in descending order, stating with the highest levels of the federal government and descending downwards. It starts with senator or representatives in Congress, then lists electors of president and vice president, and then ends with the catch-all phrase of any office, civil or military under the United States or under any state. To lump the presidency in with any other civil or military office is odd indeed and very troubling to the court because, as the intervener, so Trump, points out, Section 3 explicitly lists all federal elected positions except the president and the vice president. So she's looking to the language itself here. And she's saying, I don't think the president should be included in the catch-all phrase, but let's figure out why. Here, the court holds that it is unpersuaded that the drafters intended to include the highest office in the country in the catch-all phrase, office under the United States. So, she does go into if previously took an oath as a member of Congress or an officer of the United States. Because President Trump was never a congressman, state legislator, or state officer, Section 3 only applies if he was an officer of the United States. So she pulls that piece in as well. Professor Maglioka testified that during Reconstruction, the President of the United States was understood to be an officer of the United States. So that's important, but let's bump down to this footnote here. I think this is really what helps everybody. I know, it kind of gets weird. It gets a little weird. In response to the argument that it would be preposterous that Section 3 of the 14th Amendment would not prevent Jefferson Davis from being President of the United States, the court notes that one possible reason why the presidency was not included in the positions disqualified is that Section 3 clearly disqualifies electors for the office of the president and vice president. Perhaps the thought process was that by excluding electors who are former oath-swearing Confederates, there was effectively no chance of a former Confederate leader becoming president or vice president. So her rationale, okay, everybody, because I know you're all like, what? This is crazy. Her rationale is the reason why president wasn't included was because there wasn't a chance that a president could have been involved as a Confederate soldier. That's why she's saying president wasn't included, because of what was happening at the time. Is everyone following me on that? We didn't ever think, yeah. So she's not saying, they forgot to include the president. No, she's just saying at the time it was written, they were trying to keep all the Confederates from coming back and assuming power. There was no assumption that a president who had sworn an oath to the Constitution would be part of an insurrection breaking off the country. How could they have even thought that President Lincoln would have been part of the breaking off of the Union, right? So they wouldn't have listed him. So they did not list the position of president. They never thought it would be necessary. Exactly. So this is what some people are saying they're calling it a technicality. And I'm not sure that they're wrong. I think this idea that the name president, the position of president was not included is absolutely a reflection of the time at which it was written. But because we look at contemporaneous times and we look at what's happening now when we are interpreting the Constitution, not just the intent, I think she could be overturned. I think historically she's absolutely on point, but I think if we went into the actual application of the Constitution, yet there are people in Congress who participated. True, very true. So she's going into the Attorney General's first opinion, stating that the officer of the United States was used in the most general sense without a qualification in Section 3. The next sentence, however, would cut against including the president when Stanbury states, I think as he here used, it was intended to comprehend military as well as civil officers of the United States who had taken the prescribed oath. The president of the United States as a mere civil officer is counterintuitive. So again, is purposefully weak. Perhaps, Georgie, perhaps. The court holds that the more obvious reading of Attorney General Stanbury's opinion is that his reference to the most general sense and without qualification was to make it clear, unlike with the state officers, the phrase applied to all lower-level federal officers so long as they took an oath and did not apply only to the upper echelon of the military and civil ranks. So we've got this huge history behind it. So the history here is basically saying they had not factored in the president's oath as one of the oaths when they're considering what an oath is under the 14th Amendment. All right, so she goes on further to kind of go into the rest of the arguments. Now, I won't go through these because I think these next 5 paragraphs really set out her rationale for why she included it. The president does take an oath. The president does. But at the time the 14th Amendment was written, they did not have the president's oath in mind with reference to that, so it wasn't included. It was also kind of a mess after the Civil War, right? Like, was everyone thinking clearly? No. There were mistakes made. There were a lot of mistakes made, but it is a different oath. It is. You're correct. But it is an oath, nevertheless, but not an oath specified. It's an interesting idea. So let's go through her rationale. She explains a little bit further here. So the interveners argue that 5 constitutional provisions show the president is not an officer of the United States. So let's go through. The Appointments Clause of Article 2, Section 2, Clause 2 distinguishes between the President and officers of the United States. Specifically, the Appointments Clause states that the President shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. All right, the Impeachment Clause of Article 2, Section 4 separates the President and Vice President from the category of civil officers of the United States. The President, Vice President, and all other civil officers of the United States shall be removed from office on impeachment for conviction of treason, bribery, or other high crimes and misdemeanors. Okay, the Commissions Clause of Article 2, Section 3 specifies the President shall commission all officers of the United States. And the implication is then that he is above that position because he's the one that commissions them. In the Oath and Affirmation Clause of Article 4, Clause 3, the President is explicitly absent from the enumerated list of persons in the clause required to take the oath in support of the Constitution. The list includes the senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states. That's Article 4, Clause 3. Article 6 provides further support for distinguishing the President from officers of the United States because the oath taken by the President under Article 2, Section 1, Clause 8 is not the same as the oath prescribed for the officers of the United States under Article 6, Clause 3. There you go. The court agrees with the interveners that all 5 of those constitutional provisions lead towards the same conclusion, that the drafters of Section 3 of the 14th Amendment did not intend to include the President as an officer of the United States. That's how she comes to her conclusion. Now, personally, one of the weaknesses in this argument here is all of these articles were originally written by Madison, which was a very different time and a very different situation than when the 14th Amendment was written again. So if you look into the history of the writing of these articles, it's very different. And in fact, originally, and I think I've posted about this before, there was originally a discussion about having a king. And then there was a discussion about Madison himself wanted state legislatures individually to choose the president. So there were a lot of problems. Insurrection's not treason. Well, according to the language they're using here, according to that specific language, that's why we get into these questions. Is it the exact words themselves, what they mean at the time, what they mean now, or what they thought they meant then? You know, that's how this can get very philosophical. But again, I mean, if you do look at the intent of Madison and Hamilton when they wrote those articles, there's a huge history behind that. It's not just the history of the 14th Amendment if you're going to be pulling in different pieces of the articles. They modified it back then. Why can't we do it now? We absolutely can. We absolutely can. Here, after considering the arguments on both sides, the courts persuaded that officers of the United States did not include President of the United States. Again, I think that that's a bit of a stretch, especially considering that George Washington was an officer and was unanimously called to come in. You know, it's a funny story. John Hancock actually wanted to be president, but George Washington wore his uniform every single day. And so there was this air of authority about him. So technically, he was the first original officer, in my humble opinion. All right, here we go. While the court agrees that there are persuasive arguments on both sides, the court holds that in the absence of the president from the list of positions to which the amendment applies, combined with the fact that Section 3 specifies the disqualifying oath is one to support the Constitution, whereas the presidential oath is one to preserve, protect, and defend the Constitution, it appears to the court that let me finish the sentence and I'll pop back over to that footnote, everybody. Whatever reason, the drafters of Section 3 did not intend to include a person who had only taken the presidential oath. So let's bump back to this oath question. Number 19, the court agrees with the petitioners that an oath to preserve, protect, and defend the Constitution encompasses the same duties as an oath to support the Constitution. The court, however, agrees with the interveners that given there were two oaths in the Constitution at the time, the fact that Section 3 references the oath that applies to Article 6, Clause 3, officers suggests that that is the class of officers to whom Section 3 applies. It's a stretch, in my opinion. It's a bit of a stretch. I see where she's coming from, but it's a stretch. Interesting, though. I mean, it's absolutely fascinating how her mind worked on this. I think it's very interesting. Yeah, David, I think she has a very interesting take on it. I'm not sure historically and legally that it will be upheld, but I think it is a very interesting perspective. All right. So, we've got one more here, 20. Whether the omission was intentional or an oversight is not for this court to decide. So this is where she's saying there's a question that needs to be resolved. So the other thought that I had is that she's pointing out this glaring issue to the Supreme Court, because who else has been talking about this? Who else has been talking about whether or not the word president was included or not? So the defendants are bringing it into their arguments. That's a huge argument. They're saying we didn't have to, it's not in the oath, blah, 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 blah. So she's pointing out that there is this error in the Constitution, and she's pointing it out so the Supreme Court can see it. She kicked it downfield. I think she probably felt that she didn't have the authority to make that level of a decision. It may very well have been an oversight because of the court's knowledge. Trump is the first president of the United States who had not previously taken an oath of office. That's the other thing, right? So he hadn't served in any kind of a position in the House or in the Senate or in the military, or anything else, if you think about it. Even Ronald Reagan was the governor, so he took an oath. So everyone had already taken an oath, but he had not. So that's a really interesting question. Here we go, bumping back up again. To be clear, part of the court's decision is its reluctance to embrace an interpretation which would disqualify a presidential candidate without a clear, unmistakable indication that such is the intent of Section 3. As Attorney General Stanbury again noted, when construing the Reconstruction Acts, those who are expressly brought within its operation cannot be saved from its operation. 200,000, thank you, everybody. Where from the generality of terms of description or for any other reason a reasonable doubt arises, that doubt is to be resolved against the operation of the law and in favor of the voter. Here, the record demonstrates an appreciable amount of tension between competing interpretations and a lack of definitive guidance in the text of historical sources. As a result, the court holds the Section 3 of the 14th Amendment does not apply to Trump. All right? So we've got one more footnote here. Let's bump down. The court is mindful that Stanbury was considering disenfranchisement, not qualification for office, and that he was interpreting a statute he considered criminal and punitive in nature. The court nevertheless finds that the principle articulated that the law ought err on the side of democratic norms, except where a contrary indication is clear, is appropriate and applicable to the circumstances. So we flip it over. In conclusion, pursuant to the above, the court orders the Secretary of State to place Donald J. Trump on the presidential primary ballot when it certifies the ballot on January 4th. Translation of this paragraph. So translation of this paragraph or the footnote. Oh my gosh, the footnote. I'm exhausted. It was a roller coaster. It was. It really was. All right, of the footnote or of the paragraph? Oh, yes. Wait. Which one? Footnote or paragraph? I'm confused. He shouldn't be able to run both. Okay. All right, so here's what she's saying, everybody. She's saying it's unclear. It's unclear. And when in doubt, she's going to not take him off the ballot. She is not certain that the language would cover him. So because of that, because she has doubt, she's saying you don't need to put him on the ballot. Now, what she's saying down here when she's talking in this footnote is she's saying the reason why there's a doubt because of Attorney General Stanbury and his discussion of what this all meant was he was actually using phrasing things with the intent that there would be criminal sanctions. So that was another issue he was dealing with. And she's saying, well, I'm not going to deal with him and his thinking there should be criminal sanctions. I'm going to put that to the side and just give an overall interpretation of what he meant. So there's another open door for what exactly the meaning was behind the Attorney General Stanbury's position on this. So she's saying, I don't know exactly. Attorney Stanbury said it probably doesn't, but if you look at it from a criminal or penal and punitive standard because of the nature of it, it might, but I'm not sure. So because of that, when in doubt, we're throwing it out. That's why we have SCOTUS. Exactly, Daisy. Exactly. Doesn't list the who mean it implies to all? It does, Kristen. It does. I think there's some really good points in here. I disagree, but I think there's some really good points. He was the president. He did take an oath. He did. But what they're saying is he didn't take any other oath besides the oath of presidency. He took no other oath. My question is, did he ever serve on a jury? Because you have to take an oath when you serve on a jury. Did he ever do jury duty? Did he ever have any position anywhere in his entire life where he had to take an oath to uphold the law other than the presidential oath? Because that's what they're distinguishing between. They're saying the presidential oath is not counting the same oath that was meant in Section 3, which, because at the time they could not have imagined that it would be applicable. Bone spurs law. Like marriage, I don't know. Was he sent to military school? If he was, that could be. He dodged the draft. I think, money law. That's bonkers. Kristen, you're so right. Jury duty runs. Really? Okay. That could be a possibility, although sometimes that oath is done once you're done with your jury duty. Could he have taken an oath in military school? Yes, all you have to do is previously take an oath to uphold the Constitution. Any situation. So what do we have? Do we have military school? Do we have jury duty? What other situations do you have to uphold the Constitution? I mean, if you get your driver's license, you have to uphold the rules of your state, right? Do you have to uphold the Constitution for your driver's license? Constitution? I don't know. What about testifying if he's taking an oath? So you have to swear to tell the truth. You don't have to swear to uphold the Constitution. Excellent point. He did go to military school. That should count. All he has to do is take the oath once, man. Voting license in Missouri. Okay. What's the difference between the oath in question versus the presidential oath? So what they're saying is the rest of the oaths that were involved had to do, they're saying that they had other positions. Like if you were in the House of Representatives or a senator or in the military, you took an oath to uphold the Constitution. So what they're saying is the presidential oath in and of itself, because it's in the Constitution, it's written different than other oaths, that is not the oath that can be the one that they're saying you swore an oath to. That if that's the only oath, it's not enough of an oath. What about the Pledge of Allegiance? Excellent question. Not technically an oath. Perhaps because he was a minor when he went to military school, though. True. He could have turned 18. He's enrolled in New York Military Academy, private boarding school. It's a question, everybody. I would say it's a question. He was under 18, so being a minor would be a good question. But he did previously take an oath. Are you telling me that there weren't Confederate soldiers who weren't 18 taking oaths? You know what I'm saying? Tried to overthrow the government, steal the elect. Well, right, Amy, everything you said is true. But technically, we haven't had this kind of a situation. We did not plan for it. Saying the Pledge of Allegiance. Oh, I know, Cozy. Well, and they changed it, too, in the 50s. They actually changed the wording. I had taken an oath as the groundskeeper for state parks. Yes, anything, any kind of position whatsoever. If he worked any polls, if he did anything at all, in any way, where he had to uphold the Constitution. I'm wondering too, a lot of times, here's my other question. A lot of times in legal documents, especially business documents, you have to swear to uphold the law. Now, is it just the business law or is it the Constitution? That's another question. Yeah, deposition wouldn't be enough. You have to swear to tell the truth, but not uphold the Constitution. Go to PBS, look for Trump. Look for Trump the bully. How military school shaped him. Oh my goodness. U.S. military, more like the... Oh my gosh. His sister was a district court judge. That is ironic, isn't it? He would never serve the public. That's a good question. I mean, I think, and the fact that he's the one that brought it up in this case is fascinating. He brought it up. He's the one that said, look, dudes, I haven't taken an oath anywhere else in my entire life. And so it doesn't apply to me. And the presidential oath doesn't apply to me. Now, of course, we're going to need to have the Supreme Court come in and make that decision. Does the presidential oath qualify as an oath under the 14th Amendment? So we're going to need to have some of that. But it's a great question. And it's another one where you think he was completely different candidate. He was complete different person that was brought in as president. No political background, no state representation, no local, county, nothing. No political background whatsoever. And every other person that's come in as president has had something in the past that they've done. The one truth he gave. Oh my goodness. It should count. I agree, Sharon. And I think ultimately it will count. I think ultimately that's how it will. Took the oath for governor. Yes, he did. He did. Commander-in-chief. Well, that's a question. But was that before? Your time and knowledge immensely appreciated. Thank you for doing these lives. Oh, you're welcome. You're very welcome, everybody. You're very welcome. And I'm starting to feel my voice. My voice is starting to go a little bit. So I think I will have to, unfortunately, start to do my signing off process here. But I feel like it's very dangerous stopping someone with similar background from doing the same. Great point, Jay. Great point. And I think that's something that needs to be considered. And I think that's one of the questions the judge is putting out too. She's like, hey, did you guys realize that you had this weak link here? I'm kind of sorting it out for you. So there we go, everybody. There's the Colorado cases, signing the business documents. That's where I'm wondering. Hold on. Let me set up Rahimi. Really? Okay, go for it. Ooh, Rahimi, I'm so excited. Okay, so merch for a while. Oh my gosh, Kristen, I'm sorry, I'm sorry. Yeah, I kind of it's been 3 hours. You've earned a break. Take care. Yes, I will. I just ran out of tea. Thank you. Yes, of course, everybody. Well, thanks for coming. I will be back again tomorrow. We have a few more fun things to do this week. Oh, Deborah, thank you, everybody. Thanks, Deborah, for staying so late. Appreciate you. Oh, well, you're welcome. Thanks for coming, everybody. So hopefully this kind of clarified some things for everybody, and we can see it's not quite as open and shut as we thought. There's a lot of wiggle rooms here. Can you do a Q&A live? Absolutely, I can. Absolutely. Yes, take care, everyone. Thank you again to all the moderators for all of your hard work. So thankful for your time that you spend with me. I'm very, very grateful. It was a roller coaster. It was like, I'm gonna need to like meditate or something for a while. Oh my gosh. Yes. Well, take care, everyone. I will see you. Oh, Greg, always good to see you. I will see you all tomorrow. I will be back again 7 o'clock. So take care. No punching tonight. I agree. I agree. Oh, have a fantastic night, everybody. Thanks again for coming. I'll be back again tomorrow.